the challenge of the award is in that sense, my lord, the game plan of the particular NIT was changed after the opening of the bid, my lord. That is the whole thing, my lord. The bid was sealed bid was opened after the financial bid, my lord. There is a tie, and thereafter, my lord, again sealed bid was asked, my lord, without being retendered, my lord. That is again after sealed bid was financial bid was opened, my lord, there is a tie. And to break the tie, my lord, again the financially qualified bidder was asked to made a fresh bidding, my lord, without the covenant of the particular tender condition, my lord. And the retender is required to be made, my lord, without being retendered, my lord, and the same tender, my lord, fresh financial offer being asked. Lord, if this matter, my lord, can be taken up on Monday, my lord, because the, my lord, award of contract has already been issued on 17th, my lord, the work order to be issued, my lord, soon.
So work order issued, then what remains?
My lord, work order will be issued, my lord. It's not issued as yet.
25 तारीख Monday, Tuesday.
Out of extreme compulsion, I am mentioning this matter, my lord. It's a matter pertains to legal guardianship. Matter pertains to legal guardianship. Order has not been uploaded yet. Supposed
Which
one? Legal guardianship matter. Lastly, heard on 13th August, my lord.
Schizophrenia,
my
lord.
lord.
It will come Monday. It will come.
Yeah,
because they lost the file. Now it has been traced out. It will list. Not necessary.
My private respondent is regularized.
No urgency today. Only I will take the unlisted.
Lakshmi, may I have your kind leave to mention item number?
Every day I will not allow. Go through the my colleagues. Yes, what is an unlisted?
My lord, I am covered by your lordship's order, my lord. I am leading him, my lord. If your lordship kindly permits me, my lord. I am covered by your lordship's order. Without giving notice, my lord, they have taken an inspection, but the RDSO, and has blacklisted me without even considering my case. And the matter was pending before your lordship. And they have just blacklisted me very urgent, my lord, or else all my supplies are going to go, my lord, because these are rate pads, my lord, which will obviously, my lord, go out of circulation and wouldn't be in the position to be used, my lord. Kindly consider Tuesday, my lord, if your lordship kindly permits, my lord. My lord, 17th we have got it, my lord. 17th of August we have received.
What is the time period of the blacklist?
My lord, that's the problem, my lord. They indefinite. Once they are saying it's temporary blacklisting, once they are saying it's an outright blacklisting.
26.
My lord, 26 is a holiday, my lord. My lord, 26 is a holiday, my lord. My lord, 25th kindly, my lord. 26 is a holiday.
25th ko kar do. Issue notice.
Yes, we'll do that, my lord. Very good.
Within 10 minutes.
Very good.
Lordship.
Come on, 27. Come on, 27. Okay,
Lordship.
come on, 37. If it allowed the mentioning, so I have made a mistake for allowing the mentioning. Then
Lordship, with extreme urgency.
Not that it is declared holiday, it will come on the next day. What is the necessity?
My lord, my matter is under urgent motion, my lord, but it is 147. It's bit urgent. It's because the father is dying. The last day I moved, the daughter was not allowed to meet her father. Now he is just in a deathbed, my lord. It's just maybe allowed. It's 147.
You are not able to satisfy this court on that day. I have taken the matter.
Yes,
You had appeared. You are not able to satisfy this court.
Yes,
The court is asking, sir, question. You are not able to satisfy who is the mother, who is the father, who is in bedridden, who is in hospital. You are not satisfied. That's why the court is
order was passed. Order was passed.
Yes, order was passed.
Item 147.
Okay.
But my lord, the lady has to go back, my lord. She has already taken a leave again. She stays in New Jersey, my lord.
So what can
she has already cancelled her tickets, and my lord,
opportunities giving to you. You person not able to satisfy this.
We have already served.
Which
and
matter?
Done all 147.
Okay, let us see.
I am seeking leave.
Lordship, with in extreme urgency, I am seeking leave. I am seeking Lordship. Lordship, in extreme urgency, I am seeking leave of your lordship to file this writ petition, your lordship.
Upgradation come on Monday. Today I will not take any matter with regard to application and all these things. If any interim order extension, please mention that, or unlisted I will take. Otherwise,
Your lordship will kind.
70, my bank account has been freezed.
please.
70.
Ah.
And that is the urgency, my lord.
So what is the matter? Where is?
Item number 105, my lord.
Okay, let me see to that.
My lord, covered by your lordship.
Let us see.
I mentioned in on Friday, first week of August. Your lordship, please to place the matter as directed to the officer to place it within 10 on the following 1 week. But despite that, my misfortune, my lord, they are not stressing about the file. It was in the list of the June, my lord, monthly. Thereafter, it is disappearing. My matter is very urgent. KMD matter, one matter your lordship disposed of. But another matter, I mentioned 2 matters at a time. But
So-
my lord, your
So
lordship
if the file is not traceable, what the court will do?
Yeah,
Can-
say
can-
file is here.
Can you think that the court will come and then? So you are telling that. So no, if we already have given the date, my officers are tracing the files. They are also in burden now. Now you seen that there is a girth of officers also in the High Court. So what can be done?
My lord, file is here, my lord, kindly, my lord. My lord.
You search it out. Where is the file? How you are telling that the file is here? Why? What is the enemy between you and my officer? Your file. Then you are telling the file is here.
My lord, some matter my lord delisted on the monthly list of July. Their matter was their matter. My lord, very
तो लेके रखो बताऊंगा देखो.
Lordship, I'm seeking your lordship's.
What is the urgency?
Lordship, matter relates to West Bengal Highways Act 1964. My statutory appeal is pending. Now, during pendency of the appeal, the authorities are trying to demolish my structure. This is the urgency, your lordship.
I
I'm
can't
covered by
hear
your-
you, sir.
Lordship, my statutory appeal under the West Bengal Highways Act is pending consideration before the appellate authority. Now, during
Yeah.
pendency of the appeal, the concerned authorities are trying to demolish my structure. I am covered by
Correct.
your lordship's own order, your lordship.
So you go and approach the appellate authority.
My appeal is pending. I have
You are
approached the appellate
mentioning before
authority.
the High Court. You go and mention before the appellate authority. Give the trouble to the appellate authority. Why to the High Court? Yes.
Lordship, I'm covered by your lordship's own order, your lordship.
Date on the presentation form was last Thursday. It has not appeared. Urgency is not glaring. The only issue is, your lordship, the respondent registering authorities, despite a settlement agreement, has landlocked the plot of land. Lordship, it's encumbering my industrial process. Your lordship, it need not be listed absolutely Monday, but your lordship, there is some glaring urgency. Despite lordship filing, it has not appeared. I'm just lordship I'm so grateful.
I'm to mention one matter for
ले उन मैडम का क्या देखो?
prosecution lordship. Non-prosecution
Huh?
lordship. Non-prosecution.
It is listed. Which item?
Not in the listed.
Not in the list. उसको ले लो. Monday रखो.
May I have?
Yes, call the list.
May I have my extension of interim order?
Huh?
Extension of interim
When?
order. On 26th of August.
26th of August.
It is expiring lordship.
26th of August.
The interim order is expiring lordship. On
So
25th
25th
of
to be mentioned में रखो.
Your lordship, may I mention a matter, your lordship? Your lordship, in item number 438 in the monthly list. Item number 438 in the monthly list, your lordship. The urgency is that we have removed one of the director. ROC is the party in that writ petition. We
Who?
have removed ROC is the party in that writ petition. We have removed one of the directors, but the same has not been updated in the master data, your lordship. For that reason, we are not able to file our financial statements, your lordship. The last date is in September, your lordship. That is the
September, there is so many days. Yes, call the list.
Well, may I just may before your lordship calls the list, well, item 57. This is that West Bengal Chemical Industries. Well, it was a state, if your lordship recollects, there is a unit which we are trying to set up in Asansol. There is a unit in Lake Town. Pollution Control Board has said, please shift. It is our land, government land. Well, they have filed a report. Now, in the change of the government, we were hopeful, so was your lordship, that now the industrial policy of the government will change. So after that, the matter couldn't be taken up because the period is expiring.
When?
Well, I think it is on the 31st of August.
Okay. Monday, come on Monday.
Any
We'll
day
see to that.
convenient to your lordship. 57.
I will see to that.
Right. Grateful.
Yes, call the list.
5, my lord. This
Yes.
matter is appearing at our instance.
My lord, I am
Well, that
appearing on-
willful defaulters matter, your lordship has been. May I just complete one sentence, madam?
Only I am saying that I am appearing on behalf of bank only.
Okay,
I am not saying anything else.
Well, there is an interim order passed by your lordship, which has been extended from time to time, 19th of June 2026.
So it is till today.
Yes, my lord.
So you want extension?
No, my lord, I want, my lord, affidavits have been complete.
Hmm.
They have filed their opposition, to which I have filed my reply. My lord, now the writ petition has to be heard, finally heard and disposed of. So I was respectfully submitting, my lord, the interim order could be extended till the disposal of the writ petition.
Yes, madam.
My
So
lord,
they have
point
accepted the
comes
interim
here,
order.
my lord, that the pleading is completed. Kindly fix the matter as the earliest, my lord, as because the huge public money is involved in this issue. And my lord, the interim order until the disposal of the writ petition, the interest of the bank will be highly prejudiced, lordship. I'm only beseeching your lordship, kindly fix the early date.
Willful defaulter, public money.
Copy of the EU and ARBB served. I have already made numerous.
Give the copy. Give the Reserve Bank of India.
Oh, Reserve Bank, certainly.
Father of the bank.
Oh, yes, certainly. Certainly. No, copy the Reserve Bank. Certainly.
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner has filed affidavit in reply after serving the copy to the land counsel appearing for the respondents. Let the same be kept with the record. Counsel for the petitioner submit that the interim order is still today and paid for extension of interim order. Then at counsel appearing for the bank raised objection and submits that pleadings have been completed and the matter is to be heard as early as possible. At the land counsel for the respective parties, this court find that the pleadings has been completed and matter is ready for hearing. Let the matter appear on.
My lord, kindly little early date, my lord. My only
देखो 12 बजे कुछ है
September, in the month of September.
सितंबर में 18th September at 12 noon. Interim order is extended till 22nd of September 2026 or until further order whichever is.
Wait.
Yes, next.
I acted lordship. I appear for WBCTC lordship.
They have been asked to not file their exception.
This exception is ready, my lord.
The special officers report.
No copy has been served, my lordship. Exception is ready and it is with me, lordship. What I am praying at this stage, lordship, 1 week's time, lordship. My senior, Mr. Vidut Kumar Haldar, is in this matter, lordship. He is seriously ill.
Who are you?
I am the respondent number 7. The
private respondent?
Yes, lordship.
Yes.
Lordship, exception is ready and it is with me, lordship. I am praying next week, lordship.
Copy may kindly be served upon me, lordship. The WBCTC.
So copy.
Lordship.
So copy.
But I am also serving the flight without exception.
Whole issue in short is this, my lord, direction to give connection.
Yes, that is the only.
We tried your best. Just by replacing my lord, remember everything.
So what I am praying, lordship,
Huge
the matter will be taken up any day next week, lordship.
Huge objection.
Any day, lordship, next week.
The alleged contempt number 7 has filed. Where is your exception?
Lordship, I have just handed over the copy of the exception.
Has filed exception. Counsel for the petitioner has filed a reply to the said exception. Let the same be kept with the record.
Lordship, I also handed over a copy of the exception to the
contempt of place for time. According case is adjourned. Let the matter appear on 8th September under the same heading.
Grateful, lordship.
Would your lordship be kind enough to either, my lord, after 13th or, my lord,
The matter has already
or 14th?
After 13 or
14th, lordship.
September.
13th is okay. 15th September.
Lordship. Grateful. 15th September.
Grateful, lordship.
Next.
Seven, my lord, for the alleged contemner. My
My lord, in item number 7, I beg to appear on behalf of the petitioner. My lord, I am
I
appearing
handed over all the testimonial regarding return of the money part, my lord, stayed till disposal of the appeal. My lord, order not uploaded, my lord. Yesterday, order passed, my lord. My lord,
My lord, may I make just one submission, my lord, that I am appearing virtually?
Virtually.
Yes, you got the testimonial.
Yesterday, my lord, pursuant to the direction of the Honorable Division Bench, my lord, they have handed over the original documents, my lord, and as far as the money is concerned, my lord, his lordships were of the view, my lord, let that be the outcome of the appeal. That's all.
We got an order. It is submitted by the Land Council for the alleged contemners that as per the order passed by the Honorable Appellate Court, the alleged contemners have handed over the original testimonials to the petitioners. As regard the return of the amount, the Honorable Appellate Court has fixed the matter for hearing. In view of the above, this court finds that at present no order can be passed in the contempt application. Accordingly, let the contempt application go out of the list till the disposal of the
obliged to
liberty to mention, my lord.
With the liberty to mention.
Obliged, my lord. Grateful.
Next.
Alleged contemner none.
My lord, the affidavit service. Problem is that, my lord, day before yesterday, my lord, I have taken leave and your lordship granted leave. That day, my lord, private respondent has been served by both by speed post and also by courier. But I think they have not received. I don't know. The fact is this, my lord, I would have not disturbed your lordships regarding the tender matter because it is an administrative issue. But here, there is serious irregularity, serious illegality that has been, after the leave has been taken, that has been admitted by the respondents and they have given us the letter. My lord, I am showing that. Firstly, my lord, page 22. It is a tender. P1, my lord has got it. Name of the work, annual maintenance work related with EI and lighting system installed at Bolpur Subdivisional Hospital and Bolpur Sub-Correctional Home under Bolpur so-and-so under Birbhum Electrical Division PWD during the period for 365 days. But what happened, my lord? 4 of the tenderers have dropped the tender. I was there. And my lord, on 21st July, for insufficient documents, my tender was rejected at 3:45 p.m. Just after 7 minutes, the tender was opened and the private respondent has been given the bid within 7 minutes. Fact is this, as per memorandum, my lord, they would have given us opportunity to file the documents which were required by them. My lord, I am placing the memorandum which is at page 48. Annexure P7, my lord. Annexure P7 48, the memorandum says, my lord, para 2nd, it has been observed that in the bidding process and system of qualifying, disqualifying the bids based on bidding documents uploaded by the bidder in e-portal, some tenders are being rejected in pre-qualification stage due to minor clerical rectifiable deficiencies in the uploaded documentations of the bidders, which do not make any material difference in the technical financial capacity of bidder. It has also been noted that authorities reject these tenders bids without giving any opportunity to the bidders. Next paragraph, in order to make the whole bid examination process transparent, all authorities implementing the work on behalf of the PWD Government of West Bengal, here also PWD, hereby directed to give an opportunity to the bidders whose technical bids are found defective to explain their position within 7 working days, either through email or sending hard copies to the messengers after receiving the clarification of deficiency, so and so, my lord. So there was a scope to allow us to furnish the documents, but they have not done so. Within 7 minutes, they had opened it. And on the couple of days thereafter, my lord, they have given the provisional tender, provisional work order to the private respondent number 6, my lord, at page 45. 23/7/2006.
What is the reason of cancellation of the technical bid? Your technical bid was cancelled, rejected.
For insufficient documents submitted by me,
Where is that?
my lord. My lord, page 42, annexure P3.
What is your name?
My name is second, my lord, Mukherjee Light Decorator.
Mukherjee Light.
Insufficient documents, my lord. But I have given representation on 3rd August. That was not considered. Thereafter, my lord, after taking leave and serving them the copies, my lord, I have to file a supplementary affidavit. They have said that there was a wrong. My lord, page 13 of the supplementary affidavit. P10. আপনার কাছে কপি নেই? আপনাকে বলেনি ইনস্ট্রাকশন কিছু?
কপি আসেই কি করে হবে?
Yes.
P10, my lord. P10
Page
of the supplementary affidavit, page 13, my lord. Sorry, my lord.
Yes.
My lord, the reference is your representations dated 3/8/2026 and 10/8/2026. Repeatedly, I said my documents were not considered. I have not been given the opportunity. My lord, they said with reference to your representations, the technical evaluation and submission of shortfall documents for the work order under NIQ so and so, please be informed that your communication has been formally admitted for administrative examination. Now they say, my lord, after filing this writ petition and after serving them, the points raised in your submission are currently under active review in accordance with the prevailing West Bengal so and so and departmental rules. Subsequent decisions on necessary official actions will be communicated to you in due course. So if that it be so, then how can the work order remain? Let the work order be cancelled and they consider my case.
Where is the work order?
My lord, work order, work order is at, my lord, page 45 of the writ petition, annexure P5, 23rd July 2026. Let that be set aside. Let them consider my case. Then they have admitted that there are irregularities, there are illegalities. And my lord, interesting thing is that my bid was 3 lakhs less. I have quoted rate 3 lakhs less than the private respondent number 6, who is continuing with this work for last 15 years in the office. For last 15 years, he is continuing. My bid was 3 lakh less. So there is a public fund, 3 lakh less I have quoted. So let that be considered. After allowing us to file the required documents.
Where it is a provisional, where is the provisional it is recorded, no? In the work order, there is no provisional order.
Provisional not said, but we have heard that provisional.
No, it is the work order.
Work order.
This is not a provisional work order.
But they have said now they are going to examine my documents. So automatically this will go, my lord. That is their submission.
Yes, who is appearing?
So yesterday night I was informed it. The petition is not yet in my hand. Petition is not yet in my hand. Please some times for submission of opposition.
What will happen if this private respondent is continuing the work? Then
that
what
is
will
not
happen?
Started their work.
What would happen? In one hand, you are admitting that his representation is there. It is in under active consideration. It is also admitted he has quoted less than the 3 lakh rupees of the which you have selected. So what will happen if tomorrow you consider it favorably? Then what will happen?
My lord, please allow some time for.
I will allow. I am asking the question. I will allow you here. No problem. But kindly come to the page 45. If the work order has been issued to the person who has quoted more than the amount quoted by the petition and petition document is not considered, it is under active consideration and it is your document, not the document of the petitioner, then what will happen?
Is need for information.
Huh?
Need for instruction from them.
Come Monday.
Well,
Come Monday. If you Monday, then otherwise I will stay this order. If you say you will come on Monday with the instruction, then I will keep on Monday. If you say you ask further time, then I will stay the impugn order. Choice is yours.
So my lord, just Wednesday, 2 days.
Then stay.
Today Friday.
Correct. Friday, Saturday, Sunday, no work can be executed. So you take Saturday, the PWD work continue on Saturday also. Executive engineer office is open on Saturday also.
My lord, kindly Wednesday. Just 2 days more.
Okay, I am staying then. Correct. When I record your consent, you consented to stay. Tell me, the court has given option to you.
Wednesday is a holiday, madam.
Then Wednesday is holiday. Then
The Tuesday.
26 is holiday.
Just 1 day, Tuesday only.
Birbhum, well, it is only 2 hours journey.
2 days before we have served. And immediately after serving, they have said they have issued the mail, my lord, that we have done a wrong. Immediately after, on the same date, on.
And how within 7 minutes you open the financial bid? Kindly come to page 27, opening of the technical bid. Thereafter, where is the date of the opening of the financial bid? And immediately it open, pending the representation. Petitioner has filed affidavit of service. Let us semi-cut with the report. Counsel for the respondents prays for time to take instruction as he has received the instruction only yesterday night. For the interest of this case, let the matter appear on 25th within 5 matters. Come with the instruction on that day.
But Tuesday, madam.
Yes.
Well,
What is the instruction you know? What instruction? Why within 7 minutes you have opened the tender? Why you have not considered? Once you are admitting that his representation is pending, so why you have not considered that?
Okay.
My short stay may be given. Otherwise, they will continue with the
2 days. No.
only my lord, 2 days temporary.
Work order is issued, sir. Let me see.
But they have.
I will cancel it. No problem.
They have admitted. I know, my lord. I know. But they have admitted, my lord, they have done a wrong. So during the consideration, if they reject my claim.
2 days, nothing will happen. Yes, next.
Well, let it be at the top one.
Yes. Recorded within 5 minutes.
In this matter, I am appointed to the petitioner. If it is a affidavit of service, 1 and 2 are served, the main respondent, and the JE and the appellate authority was not served. But this is the case. The petitioner is a student and sat on the JE joint entrance examination and NET. She able to got her chance. But the problem, my lord, the respondent number 2 is not issuing the domicile certificate. While as per the case, my lord, she has every document. The problem with her is that her mother's name was struck off and that is pending an appellate authority. My lord, kindly come to page number 12 once.
Lordship, I have one humble prayer, Lordship. Mrs. Joitadhar Chakraborty is on with the state, Lordship.
Who?
Joitadhar Chakraborty. I am praying for Lordship only short possible, Lordship. His Lordship kindly in this matter.
You have instruction?
I have no instruction because I am not in this matter, Lordship. It is a Joitadhar Chakraborty for this. I feel short possible.
Possible. Next.
Then I am for the petitioner. My lord, they have to make a formal application for adoption of the child. Cut short this story, my lord. Your lordship has been pleased to hear out the matter, my lord, on the 27th elaborately. My lord, I filed my affidavit of the services as well as the short notes, my lord, that we have prepared. Now, what is the matter, my lord? The matter is, my lord, the petitioners are the adoptive parents. My lord, on the 24th, my lord, of February 2023, they adopt the child of the private respondents. The child was nourished by the born and brought up by the adoptive parents, that is petitioners, for the last 3 years. But after considering the paragraph 14 of my petition, your lordship had been pleased to direct them to grant me visitation, and at the same time also prepare the process of adoption in accordance with law. Now, my lord, if your lordship kindly sees the order, my lord, passed by your lordship on the 28th of July. But paragraph 9, my lord. In the meantime, the petitioners are at liberty to take appropriate steps to adopt the child legally in accordance with law. The respondents' authorities are restrained from giving the said child on adoption to any third party till the next date of hearing. Now, my lord, after this order, my lord, we had communicated to the respondents. My lord, the affidavit service are there. All the three formats we have served them, intimating the order of this court, the mind of the court, desiring them to take these steps in a logical conclusion. But after the notice was served upon them, my lord, no steps have been taken by them. In respect of the adoption, visitation is continuing, no doubt, my lord. At the same time, my lord, what I say, my lord, I have filed my written notes, my lord. If your lordship kindly sees, my lord.
They have to make the proper.
But I'm not denying that. For the single time, my lord, from day one, when your lordship is hearing the matter, but I say that the notarized deeds are not as per the law prescribed under the CARA rules. Regulations 5 is specific. There has to be a mode. But if your lordship kindly sees the orders that have annexed, my lord, the Honorable Supreme Court, in a similar matter, my lord, page 15,
yes.
But paragraph 10 to 17, I'm relying on this.
Paragraph
10 to 17.
Yes.
But here, my lord, the opinion of the court was that since the childs have been brought up by the adoptive parents for a considerable period of time, therefore the child should be first returned to the adoptive parents and then carry out the procedures, because procedures are handmade, my lord. Your lordship knows, your lordship had held in number of judgments. I am not denying that the CARA has to be followed. But if your lordship kindly sees, my lord, having heard the learned counsel for the appellants and the learned counsel for the respondents, we find that the ends of justice will satisfy the instant case by directing the return of the above mentioned child to the adoptive parents. We also say by invoking a powers under 142. Now, my lord, next paragraph, my lord. This is now a guideline has been framed, my lord, in that very judgment. My lord, paragraph 14. However, as a safeguard in the best interest of the child.
Paragraph 14
of the said judgment, my lord. Of the judgment I'm relying of the Supreme Court, my lord.
Page number?
23. 23. Internal page 9.
Yes.
However, as a safeguard and the best interest of the child, we direct the member secretary legal services such and such, within whose jurisdiction the adoptive parents reside, to seek reports of the welfare and progress of the child from the respective adoptive parents on a quarterly basis, starting from November 2025. The member secretary of the legal services or the member secretary of the district legal services will be also at liberty to depute a child welfare expert to inspect the home where the child and the adoptive parents reside. This is to ensure the welfare and progress of the child who have been returned to the adoptive parents. We again clarify that we have passed the efforts in the best interest of the child concerned in the instant case, and they have been with the adoptive parents for a few months, up to 3 years in this case. In my case also, my lord, 3 years the child was with me. It was only when I take him to the doctor for the the birth certificate, the issue crops up. Now, at the same time, but the child welfare committee, your lordship knows that a child welfare committee has to pass an order if they find that the child is in abuse, neglected, or his welfare is not been considered. There is no such order. In their said report of the first day they had filed, but they have accepted that the child was being protected by us. Now, my lord, if your lordship kindly sees the next, my lord, which I'll be relying on, I'll cut short the matter, my lord. The order, my lord, passed by the Honorable Bombay High Court, my lord, which is at page. But this issue was similar. Notarized deed of adoption was there.
My lord, page 54. Here, my lord, I'll be relying on paragraph.
Do one thing.
My lord.
Use your judgment to him.
Yes, miss. I have
Consider this, and you consult your only making oral submission will not do. You take appropriate decision, take appropriate instruction from the CVC what they are intending to go to do. You come on the next day, otherwise I pass appropriate order.
My lord, we have no bar to them, but they have to come with the proper legal
Just a minute. I know proper legal, but the child is 3 years old.
My lord.
Now they wanted to child. Now the time is the child is to be get admitted in the school.
My lord.
So how the child will go?
No, my lord.
Then, so
They do not-
if the adoptive parents are there, and the procedure has not been adopted only because of you have taken the custody, then court has passed an interim order so visiting. If you are not taking any steps, you are not guiding the petitioner, and the petitioner, the child is of the 3 years, more than 3 years of age. Now she has to admitted in the hospital, the school. All the education is to be taken care. So that's why I'm asking again and again. You go through the judgments which the petitions relied upon. What is the law settled by the Supreme Court? You also take instruction from the authority what they wanted to do. Come with a specific instruction so that the court can dispose of the matter recording your intention. You are appearing for whom?
A lot of private response.
Correct. You take that.
May I take?
My lord, kindly give it 2 weeks time, so we will make it.
Correct. You
My lord, the
take,
interim order should continue, my lord.
the petitioner has filed short notes of argument along with several judgments relied by the petitioner after serving the copy to the London Council for the respondent authorities as well as CWC as well as the private respondents. Let the same be kept with the record. Council appearing for the CWC prays for time to take instruction with instruction. According case is adjourned, let the matter appear on 3rd September. 3rd September under the same heading within 5 matters. Full stop. Interim order is extended till the next date. Next.
But within
Third.
grateful. But within 10 minutes matters. Grateful.
But I am for the petition. But this is
for point number 5 and 6. I'm taking a preliminary point of entertainability.
Item number
11. I'm taking a preliminary point of entertainability, my lord. Petitioner is seeking for specific performance of a contract, and there is no public law element.
Yes.
If your lordship sees the prayers, the
kindly come to page number.
Preliminary objection. Yes.
Point is this, my lord. There's an agreement between my lord SBSTC and my lord the petitioner that they will construct a hub where the buses of SBSTC shall, my lord, they will take a halt and then go away. Then there was not huge commotion amongst the passengers because this hub was not providing food up to the mark. They objected because of the the passengers, my lord, the public, because of the huge agitation created, my lord, the buses stopped, my lord, giving the halt at, my lord, the hub. So they are aggrieved by that. They have sustained damages. So they are asking for specific performance of the contract that the buses should stop take halt at that particular hub. So we have other defense. Defense is that if something is not incapable of being performed, if the passengers they do commotion, we cannot go against the will of the passengers and forcibly stop there. That is our defense. But then again, they are if they are entitled to damages, that is it goes to a suit. If they ask for the kindly the prayer, what they are asking for, the contract should be performed. Prayer B, all buses should be operated at the ensure regular stoppage of the buses operated by the corporation at the Muratipur bus hub established by the petitioner in compliance with the agreement. So they are asking for the agreement to be performed, and there is no public law element. It's a purely private contract.
Who are you?
I am SBSTC, South Bengal State Transport Corporation, a corporation under the Road Transport Corporation Act.
You are not listed under Article 12 of the Constitution.
Yes. Article 12.
Not the 12. Then, if the court finds that your act is not in accordance with law, if there is it is not the new, you wanted to new contract is to be executed or performed. Here is the earlier contract is going on. All of a sudden, you change your rule.
No, I'm not changing my route. Route is same, my lord. The contract
Not
is
route, I am telling you route.
halting, halting,
So
lord.
that's why.
We have stopped.
So whether the court cannot reside in that.
The court is it is
Then-
maintainable. It is
then-
maintainable. I am not taking the point of entertainability in view of the my lord's nature of the dispute raised. It is I am not.
So you come with
Prayer-
the affidavit.
I-
Why you have
kindly.
taken the decision? One, you are telling that you have received the
I
objects.
cannot say it is not maintainable. I cannot say that.
So-
Entertainability. I am
so-
taking the point of
You are
entertainability.
telling that you
It is
got
not
the
contractual dispute. That is my
when you
entertainability.
file the report.
Lordship will give me, my lord, 3 weeks time, my lord. Or what?
You have received so much instruction. Now 3 weeks time is required.
2 weeks, my lord.
Well, only thing is that if your lordship fix it after 2 weeks, I do not have any objection, my lord. Kindly fix it so that it can be taken up, my lord, because I am unable to pay the salary, my lord. That is the problem I am facing.
Learned counsel for the respondents press for 2 weeks time to file report. Let the report be filed within and let the report be filed by way of an affidavit after serving the copy to the land counsel for the petitioner on or before 7th of September 2026. Reply if any, reply oblique exception if any to the said report by 11th of September 2026. List the matter on 14th September within 10 matters.
Lordship, kindly record my preliminary objection because unless it is recorded.
Counsel for the petitioner respondents raised the preliminary objection with regard to the entertainability of the presented application. The same is kept open.
Grateful, my lord.
Next.
My lord, I am for the petitioner.
I appear for civil.
If your lordship kindly recalls, the matter relates to non-updation of civil score.
What?
Non-updation of my civil score of my client.
Official
And
report. Report. So kindly grant us 1 week time so that
there was a direction.
Yes, last time you are appearing for whom?
file report by way of affidavit. So
Counsel for the respondent prays for time to take instruction and to file report. According case is adjourned. It was July.
only for instruction. There was an order last date
No, to file report. Instruction and to file report.
From Mumbai that so after signature that
Huh?
from Mumbai.
Ah.
Signature. So that will take some time, my lord. Only 1 week accommodation.
Learned counsel for the respondent 5. Respondent number 5.
For the bank lordship. Respondent number 2, 3, and 4.
Learned counsel appearing for the respondent number 5 prays for a week time to file report. Let the report be filed by 1st of September 2026 after serving a copy to the land counsel for the petitioner. The petitioner is at liberty to file exception to the said report if any by 9th of September 2026. List the matter on 10th of September 2026. Next.
Lord, I am for the petition. Lord, taking a point of maintainability on the last occasion.
This matter relates to the compensation of a poor litigant.
Compensation of?
Of a poor cultivator.
Poor cultivator.
Yes, Lord, because
how the compensation will be calculated by this court in the writ jurisdiction?
Well, this is already they have
calculated.
We have calculated. We tried to communicate. They refused that. It has come back with the investment refused, and they have to come up before this honorable
is
court.
not satisfied because 4.5 kata total value actually 25 lakhs. They want to give only 9.
For what you want to
as per market value is concerned.
Land acquisition.
Actually, they want to encroach my landed property by installing gas pipeline. So against which only they want to provide only 1,99,000. This is too meager to accept their proposal. That is why, my lord, the matter should be heard before the district judge because when I deny their proposal and section 10 of the compensation of the Mineral Pipelines Act 1962, if my lord 10 if the amount of the compensation determined by the competent authority under subsection 1 is not acceptable to either of the parties, the amount of the compensation shall on application by either of the parties to the district judge within the time limit. So, my lord, that is why, my lord, kindly refer the matter to the district judge, my lord.
You take withdraw now. I will giving liberty to approach.
Kindly
with
give
the-
me liberty to. file.
Kindly records, my lord, there
Which
is
which
a
section? Which section?
Because the time limit is there, my
Which
lord.
section you are referring?
section 10, my
Section
lord,
10(2), my lord.
indicates, my lord, section
Section
10
10(2) of the
two
compensation of
stipulates-
the pipelines, my lord, in Section 962.
The dispute in the present application is that the compensation.
But only one objection, my lord. My lord, rule 5 says, my lord, from the date of pronouncement, there is a limitation period of 90 days. But that kindly records it, so I can take this point before the learned district judge whenever they file
So
it.
kindly give me liberty to file because I agitated before the High Court when the matter was filed.
No,
I don't get
petition
any-
itself is not maintainable. my lord.
I don't get any compensation.
Lordship
This-
sees rule 5 once.
After filing this petition, they want to provide such amount.
Rule of Lordship sees rule 5, application to the district judge for determination of compensation.
Rule 5.
Rule 5, my lord. When any party aggrieved by the determination of the amount of compensation may prefer an application to the district judge within the limits of whose jurisdiction the land or any part thereof is situated, not later than 90 days from the receipt of the intimation from the competent authority under Rule 4.3.
Yes.
Well, we had communicated to them the compensation quantum by a letter dated 19/4/2025. Which they 2025.
And when he filed the writ application.
My writ application has been filed 31st January. 31st January.
Yes.
And only that point I may be permissible to request that, but I can take that point before the learned district judge.
But give me liberty to file.
क्या बोला? Is that the damage of the compensation assessed by the HPCL? HPCL is denied by the petitioner. Now the petitioner submit that as per section 10 of the petroleum and minerals pipelines within bracket acquisition of right of user in land bracket course act 1962. The petitioner is intending to move before the appropriate court and wait for withdrawal of the writ application with the liberty to file an appropriate application before the appropriate forum. Learned counsel appearing for the HPCL raised the objection that if any application is filed by the petitioner before the learned district judge, the same would be barred by limitation. He referred Rule 4. Rule 4.
Rule 5, my lord.
Rule 5 of the Petroleum Rule.
Petroleum Rule, my lord.
Petroleum Rule 2002.
1963, my lord.
1963, and submit that as per the rule, the person and the petitioner had to apply before the district judge within 90 days from the date of the order. But in the present case, the order was passed on
19th April
19th April
2025.
2022.
25, my lord.
2025, and the petitioner has filed the present date application in the month on 30th January 2025. Police, as the petitioner intending to withdraw the present date application, and thus this court has not gone into the facts and gone into the submission made by the land counsel appearing for the HPCL. Accordingly, writ petition is dismissed as withdrawn with the liberty to the petitioner to approach before the appropriate forum in accordance with law. If the HPCL raise any point of limitation, the same shall be considered by the concerned authority in accordance with law.
I'm extremely obliged, my lord.
Item number 14, I'm appearing for the petitioner, Your Lordship. My allegation is that there has been a unilateral freezing of my bank account only on the basis of receipt of report from Cyber Cell. And Your Lordship has already passed an order on the application asking for the report.
Respondent, Bank, Standard Chartered Bank. We are submitting the report and the bank statement.
May we also have a copy of the?
Give the copy.
Yes, whatever, but you have to. And we had already written to them.
This is the way you are submitting report.
I will.
Without stitch, without pin. Huh?
May I make one humble submission, Your Lordship? I see from the perusal of the order, the information that Your Lordship has sought in the report. Of course, it has to come by way of a report, but all of those informations are available on the documentary evidence that I have annexed with the writ petition, Your Lordship. And the basis, the bank has candidly admitted the entire basis of the freezing, that is at page 85 of the writ petition, is only on the basis of instruction received from CyberCell.
So you are not allowing to operate the bank account? No, the report is otherwise.
I have to then peruse the report.
They are telling that only 3,68,000, initially 10 lakh, then the subsequent 10,61,000, then subsequently it was reduced to 3,71,600, and as per the order of the London Civil Judge Junior
33,000
Division of
has been deducted. 33,000 has been
33,000
deducted.
was deducted in terms of the order
In
passed
terms
by
of
the
the order
civil
of
judge.
the civil judge.
Civil judge, now only the disputed is 3,38,000.
But Your Lordship, as per my instruction, the bank account is not operational. Allow me to peruse the report.
If you give us the permission, we are
But
ready
your
to-
report is otherwise. You are telling that only the amount has been kept in lien. Who has signed this order, this report? Standard Chartered respectfully reiterates that the neutral intermediary holds no claim lien or interest over the petitioner's fund.
If we get the instruction, we are ready to defreeze the account.
Because in my humble submission, be it a lien of 10 lakh or be it a freezing of, both are barred by the same logic under 107. Because only a seizure under 106 of BNSS would be permissible. And that is what Your Lordship's order has held in other cases. So even a unilateral lien perhaps is
And 2023. So now 2026. So what has happened of the investigation? So how long you will keep the account freeze?
If my lord will give us the.
What about the 3 lakhs rupees? What about the 3 lakh 38,600?
now that has no basis because as per the magistrate's order.
No, that is 33,000, one of the component. What about this? Have you made the investigating agency party? Yeah. No.
No, Your Lordship.
Then you could have been made the investigating agency as a party.
We had
But you are
initially
not made.
Because only the freezing order we are challenging.
Freezing, but they have freezed the account on receipt of the cybercrime police station, Husnabad, Telangana.
That's correct.
So you could have
That's
made
correct.
a party to them.
We had contemplated, but then the order was only sought against the bank. That's the reason. And Your Lordship's order, we
No,
consider.
that's correct. But I am not allowing the whole amount which is disputed, then it will remain as a disputed, and you can operate the remaining amount.
If at all there is, may I suggest something? May we peruse the report that has been filed, because today I don't have the report, and allow me to also obtain instruction as to the present status
Yes.
and make my
Give the
submissions.
copy.
And then I can at least make my legal submissions.
Yes. But with regard to the other your account, they are ready and willing to.
According to us, there is no dispute any further, but I will peruse and obtain
And with
instruction.
regard to 3,30,000, or you, in the meantime, I will direct you to add the investigating agency as a party, serve the notice. I am fixing after 2 weeks. If they will come, they will inform, then the court will pass. That is the two things can be done. What you want?
Your lordship will kindly allow me to take instruction once, and then your
The
lordship will
bank
take
has filed the report after serving the copy to London Counsel for the petitioner. Counsel for the petitioner prays for time to take instruction. Accordingly, case adjourned. Let the matter appear on 27th.
Very well.
এটা পিন করে দে না
আমাকে প্লিজ একটা কপি দিয়ে দেবেন কপিটা নিয়ে নাও
Next.
Deeply obliged, your lordship.
Your lordship, I'm praying for not today. I'm a senior.
Yes.
Right. I'm praying for not today, your lordship. I've served upon the respondent number 3. I've served upon the respondent number 3. The affidavit of service be kept on record.
I'm appearing, my lord.
Yes.
Yes, Gypsy bank. My
Yes.
lord,
What is your instruction?
My lord, kindly see the prayer, my lord. My lord, in particularly in this particular case, my lord, they are praying for a petitioner is praying for removal of the lien, my lord. My lord, that we cannot do, my lord, in absence of the investigating agency, my lord.
Who is
My
the
lord,
investigating agency?
my lord, we have provided, my lord, it's a Gurugram Cybercrime South Police Station, my lord.
You have made a party investigating
He has
agency.
made a party, my lord. It's a respondent number 4, my lord. My lord,
That is the affidavit.
so there was a no direction, my lord. I have now I am coming with a report.
Now she will be prompt for filing a report.
My lord. There's this. Particularly for this case, my lord, is difficult, my lord, for our end, my lord, because the entire amount is 35 lakh rupees, and that is on.
Whether the respondent number 4 received the summons?
Yes, sir.
Yes.
Where is the service?
Yes, lordship.
Indicate code.
Direct to submit report. Respondent number 3.
My lord.
Branch manager.
They. Affidavit services. Zero.
Serve the investigating agency. The petitioner has filed affidavit of service. Respondent number 3 has filed report. Let the same be kept with the record. It is a contention of the bank that the bank has kept the amount of rupees 35 lakhs on lien, due to the report from the respondent number 4.
Page 2.
In spite of service of notice, none appears on behalf of the respondent number 4. Accordingly, the petitioner is directed to intimate the next date of hearing to the respondent number 4, and the respondent number 4 is directed to submit the report before this court whether the said amount is further required for an investigation or not. Let the report be filed. Full stop. Let the matter appear on 10th of September 2026. It is made clear that on the date fixed, if the respondent number 4, in spite of service of notice, not filed the report, the case will be proceeded accordingly. The petition is directed to communicate this order to the respondent number 4 for compliance.
My lord, may I pray one thing, my lord? My lord, this is particularly, this petitioner's case is related to another case, which is your lordship has kept on 9 September, my lord. My lord,
9 September?
Yes, my lord.
9
My lord, read petition number they will indicate, my lord, because that is for the initial transaction with that particular company. Subsequent this.
Come to this.
Yes, my lord. That is why the. Read.
9 September along with WPA number. What is the number? You are having number?
Yes, your lordship.
Along with WPA number?
15683.
Yes, next.
But item number 16, my lord, if your lordship, my lord, kindly permits me to appear online, my lord. I'm sorry, my lord. My lord, this is my petition, where, my lord, the demat account of, my lord, the petitioner has been frozen. My lord, if your lordship kindly takes, my lord, page 258, your lordship will find, my lord. Letter, my lord, written by, my lord, Axis Bank, where, my lord, the petitioner has been, my lord, mentioned as, my lord, a copy to the petitioner, Raghav Das Mundra. My lord, demat account of such and such is suspended by NSDL. You may coordinate with NSDL head such and such for the details of the demat account suspension. Now, my lord, immediately, my lord, thereafter, my lord, the petitioner filed, my lord, issued a reply, which is at, my lord, page 260.
Yes.
Because we do not know, my lord, what this has been done, we simply write to them that please let me know the reason for which the account was frozen and what do I need to do for opening it. Thereafter, my lord, the NSDL gave a reply, my lord, which is at, my lord, page 261. If your lordship kindly takes paragraph, my lord, 2, NSDL with letters dated such and such respectively, copy marked to SEBI as per circular and based on the information of promoter of non-compliant company Simplex Projects Limited received from NSC has marked ISIN level free suspended for debit credit on the following beneficial account such and such Raghav Das Mundra. Further, NSDL with its letter dated such and such respectively have informed to DP Axis Bank Limited, and the Axis Bank, I have shown to your lordship what the Axis Bank had communicated to us. Now, my lord, this letter, my lord, we give a demand justice notice, which is, my lord, at page 262.
Yes.
My lord, at page 262, my lord, we give a demand justice notice, which is at, my lord, which is dated 2nd of June 2026, where we take this point, that, my lord, no, my lord, is absolutely in violation of the principles of natural justice. My lord, suddenly, out of the blue, when I'm not even a director or a promoter shareholder of the company, I have been directed, my demat account has been frozen. So I write to them, quoting the SEBI guidelines, also the SEBI Act, which says that section 11 to section 11 4A and B of the SEBI Act specifically states that there has to be an order with reasons to be recorded in writing, which imbibes, there's a division bench, High Court division bench judgment, which supports my case, which says that 11 4A and B of the SEBI Act, a specific order has to be passed, which has to give reasons, and it has to be recorded in writing, which automatically infers that there has to be a hearing before that, and there has to be a notice and an opportunity of hearing given after, and then only the reasons can be recorded in the order. So that is section 11 4A and B of the SEBI Act. I shall immediately place it before your lordship. Prior to that, kindly sees what the SEBI replies. This is at page 452. Kindly takes the volume 4 of the petition.
Yes.
Volume 4 of the petition, page 452. Volume 4.
Yes.
But if your lordship kindly takes, the SEBI replies at paragraph 2 that as per the circular dated 20th September 2023, investors who wish to lodge a complaint on SEBI Scores portal are required to register themselves on Scores portal before lodging the complaint against a listed company as SEBI registered intermediary. Mandatory details like name of the complainant, PAN of the complainant, contact details, etc. So, and thereafter, paragraph 3 says, on scrutiny of your physical letter submitted to SEBI, the mandatory details required as per the above mentioned circular are not available. Hence, we are not able to upload the complaint on your behalf. What we have done is that, we even wrote to the SEBI Scores portal, but, it was not possible because, SEBI scores is not an alternative remedy when specifically there is a violation of the principles of natural justice. And then section 11(4)(a) and B specifically states that there has to be an order recorded in writing. SEBI scores cannot deal with this.
Yes.
Now, if your lordship kindly takes, if my learned colleagues can hand over a copy of the SEBI.
No.
Yeah.
Lordship, I have a point on maintainability. If your Lordship allows me right now to submit, then I can do that.
Yes, what is the point?
Lordship, there is an alternate remedy available in the SCRA Act itself. If your Lordship kindly allows me to hand over the Act. Section 23L, if your Lordship would kindly.
Section
23 capital L, your Lordship. Your Lordship has 23L?
Yes.
Any person aggrieved by the order or decision of the recognized stock exchange or the adjudicating officer or any order made by SEBI. Your Lordship has that?
Yes.
Under section 4B may prefer an appeal before the Securities Appellate Tribunal and the provisions
But
of
if the principle of natural justice is violated, have you issued notice?
And no order has been communicated. Interestingly, no order. I can prefer an appeal from an order. No order has been communicated to me.
It's admitted that is under section 4AP.
Your Lordship, they have to approach the SAT.
Correct. But if it is principle of natural justice, whether the writ will not lie. Principle of natural justice.
But Your Lordship, there's an alternate remedy they can approach.
I appreciate. That's why I'm asking. If an alternative remedy, if it's going on facts, it's okay. It is applicable
case, Your Lordship, I'll
order.
show the
You have to go to the person has to go to the appellate authority.
In that case, Your Lordship, I'll show the notice that was issued to them.
On the second hand, it is totally not barred if the authorities are challenging the order on the ground of opportunity of hearing or without jurisdiction or other thing.
Kindly allow me to show the notice that was issued to them, Your Lordship. Page 96 of their petition. They were given sufficient notice. 96. And they still failed to comply, Your Lordship.
96.
Page 96. Has the letter.
Yes, Milord. Kindly takes page 96. Kindly let him show that the petitioner's name is mentioned over there.
I'll show you.
Yes, 96.
Can you see it was written to the company, Your Lordship?
So grateful, Milord.
Reference to a letter dated so and so for suspension of trading in equity shares of the company, ensuring compliance. Your Lordship kindly sees the last paragraph. The exchange till date has not received financial results and also the fine amount levied for such non-compliance for 2 consecutive quarters. Therefore, the trading in securities for a company will be suspended with effect from such and such. Now, kindly looks at page 99, Your Lordship. The communication at page 99 is addressed to them. Your Lordship kindly sees copy 2 right at the end. This is the petitioner, Mr. Raghav Das Mundra. And Your Lordship kindly sees the of this communication, 5th November 2018. Thereafter, there have been 2 further communications to the petitioner. The last communication of 2021, which is what my learned friend was showing to Your Lordship, thereafter 5 years to write to SEBI. In 2021, STL had written to them. Then they write that one justice in 2026. For 5 years, they sat on it.
Yes.
Milord, 2 things may I submit, Milord. First of all, Milord, page 99, what he's showing is not, Milord, is not a demat account freeze. Kindly sees, Milord, the letter at page 99.
Yes.
He showed very nicely, he showed page 96. He showed page 96, a letter written to the company, where, Milord, your Lordship may kindly take, Milord, pages 91, where I have resigned from the directorship of the company on 21st May 2012 itself. And thereafter, kindly sees page 99, a 2018 letter, whereby he's recording NSE, ISIN level freeze suspended for debit and credit. It is not a demat account freeze. Kindly sees this, Milord. It's marked as following beneficial owner account based on list of PANs, promoter group of the concerned non-compliant companies as provided under by NSE holding securities of the concerned non-compliant company. It is not, Milord, in my respectful submission, not a letter issued for freezing my demat account.
Your Lordship, kindly
Kindly,
compare the
Milord,
language in both the impugned communication as well as in this communication. It's the same.
Which one?
The impugned communication that was shown by my learned friend at page 261.
258, not 261, 258. That's the communication.
That is of Axis Bank. I'm talking about the NSDL communication of 261.
No, Axis Bank is the one who told us that the demat account has been frozen.
On the basis of the NSDL communication, Lordship, at page 261.
Yes.
And it refers to the previous communications. Kindly see para 2A. It refers to the previous communication of 5th November 2018. Kindly note the date of this communication, Lordship. That date has not been shown to your Lordship. It is of 28th of September 2021. He's challenging an action of 2021 now. Kindly see the previous two communications. The first communication has been mentioned para 2A. NSDL with its letter dated 5th November 2018. Thereafter, kindly see para B. The second communication was 26th December 2019. And this communication, which he is now challenging, is of 26th September 2021.
Where is that?
Can you see the date at page 261, right to the top right corner, Lordship?
Yes, September 21.
Demand justice has been sent in 2026.
May I submit, my lord?
21, he's talking about natural
Lord, 2020.
Securities Appellate Tribunal.
Yes.
Section 20L remedy was available to him.
Yes.
My lord, three things, if I may say. First of all, my lord, the letter, the email, which is at my lord, page 258, is a my lord, email by which the demat account was frozen.
Yes.
Kindly sees it is completely different from page 261. 261 NSDL, kindly, my lord, kindly allows me. He has his chance.
That is the September 2021.
My lord, yes, kindly, my lord, gives me my lord 2 minutes. My lord, 2022 to 2024, my lord, the company Simplex had my lord undergone CIRP. From 2022 to 2024, the company Simplex had undergone CIRP. My lord, may I kindly, my lord, allows me to at least, my lord, make 2 submissions. After that, my learned friend can have all its guts. So, my lord, second is that
in that case, let the SEBI file the report. Let the SEBI file the report. I think the maintainability open.
My lord,
Because
very well,
2021, there is no necessity for passing any interim order.
my lord, I am appearing for SEBI. If I may indicate one simple point only with respect to the submission my learned senior made on SEBI. The attachment is not affected by SEBI. So naturally there will not be any order of SEBI, and section 11 that my learned friend senior referred to, it will not be applicable in this present case. If your lordship sees the notice of attachment, at page 99 that your lordship saw, 5th November 2018,
correct,
attachment was effected pursuant to a circular of 30th November 2015. That circular, SEBI determined through that circular an SOP for the stock exchanges.
Correct.
Non-compliant. So, attachment was affected by stock exchanges pursuant to the SOP determined by SEBI. So, there will not be any order in writing, or even the provisions of SEBI Act will not be applicable in this present case.
so, my lord, the point of maintainability also goes away, my lord.
Lordship, I am also covered. I am a recognized stock.
You are appearing for whom?
I'm for National Stock Exchange, Your Lordship, and I'm also protected by section 23.
So, my lord, their arguments are, my lord, counterproductive to each other, my lord.
The petitioner which
Completely counterproductive to each other. My lord, I'll tell you, lordship, my lord, my urgency is that, my lord, my demat account has been frozen, which is why, my lord, my trading has been completely stopped. My lord, violation of natural justice is there because, my lord, they have not given me any notice and they have not given me any help.
I'm appearing for National Stock Exchange, which is respondent number 3, Your Lordship.
3. And you are appearing for 4.
For 1.
4.
For 1. Yeah.
For 1. SEBI.
SEBI.
Yes.
Section 23L protects me also. It refers.
And what about the 2?
Who
is appearing for 2? And who is appearing for 4? Nessa Security Depositors Limited.
May I file my affidavit of service, my lord? Affidavit of service, my lord, if your lordship can.
No service. Where is the
email, my lord?
No, track report is not there. Track report is not there. Only one is delivered.
Other
not delivered.
I'm so sorry, my lord. I should have seen this, my lord. I should
Other
have
not
seen this.
delivered.
Lord, from pages, my lord.
Kindly come to the page 10. Affidavit of service, page 10. Can you see? Where is the delivery? No delivery.
Lord, it's in transit.
Then kindly come to
not
the
yet.
page.
It's in transit. I
Page
vouch.
12.
My lord, I'm so sorry, my lord. I'm so sorry.
Why?
My lord,
Hard copies, my lord, in transit. my lord.
Come with
any day, my lord, convenient to your lordship. I'm so sorry for this. my lord.
Petitioners have filed the affidavit. Petitioner has filed affidavit of service, but this court find that the notice has not been served. Counsel for the respondent number 1 and 3 are present. Counsel for the respondent number 1 has raised the objection with regard to correspondent number 3 raised an objection with regard to maintainability of the set present date application. As the affidavit of service has not been completed, according to cases adjourned, let the matter appear. When you file the affidavit, second.
Second, my lord, we can find.
Under the same heading.
Some precedence.
Yes, next.
My lord, if your lordship my lord, kindly gives me some precedence, my lord, in this matter also, my lord.
That matters.
Very well. I'm so grateful. I'm so grateful to your lordship. So grateful.
Next.
Alright, item number 17, I appear for the respondent number 6, your lordship.
Lord, I appear for Security Exchange Board of India.
My lord, I'm grateful to you that you have accommodated me, my lord.
Everybody is grateful to me.
I will answer the two questions of my.
No, my lord, I have filed my opposition pursuant to your lordship direction. No reply has been filed.
No, yesterday, Leonard friend has, your Leonard friend has told this court that only he will raise 2 points and the case can be disposed of. I don't know what is the point. Let me see.
I am submitting my court of written note of mine.
So that means, my lord, kindly record that he does not wish to file reply.
I will tell details. My lord, I am sorry.
No, you have not.
No, you will file reply.
Yes.
You will file reply.
No, my lord.
No.
First I will tell this.
No, then.
No, whether you file reply or not.
No, I don't want to file.
You don't want to file reply.
Very well.
Okay.
So my statements remains uncontroversial.
2 points are minimum. One is validity or not. Second is interest.
Second is?
Interest.
Yes.
My lord, interest. First question that we have submitted the report on 19 September 22, 2022. And our certificate is not valid on that date. Is correct? That, my lord, at a bilateral stage, not in the beginning. They have not told in the beginning. Kindly come to page 4, my lord. Page 4 of my written note of written notes, my lord. Page 4. Page 4, para 6, my lord.
What is this?
Have you got it, my lord? Para 6, my lord. That petitioner begged to submit here with that SEBI authority had meeting with the 2 PRC chartered account. He has called for a meeting.
Now, page 4.
Page 4, 6. Then 5, page 4. Page 7. Page 4 and 7. Bottom, at the bottom.
My lord, I am not fully ready, my lord, since he has not, this is final hearing, my lord. If my learned friend completes today, my lord, kindly give me 15 minutes any day convenient to your lord.
No problem, sir. Yes. My lord, that the petitioner begged to submit here with SEBI authority had meeting with the 2 PRC on 22/5/2003, my lord. If my certificate is invalid, why you have called me and discussed me? And he has given a reply. Reply in an affidavit in the first date. Para 23, my lord. As I have written. Then, my lord, come to the 8. It is very important, pertinent to bring to the notice of my lord that the SEBI authority had directed the petitioner on 9/2/2024, my lord.
No opposition.
After my seniors tell that you have not given the date is 24 to submit all documents in response to above said letter, my lord. Petitioner has stated that the petitioner has to reply to it on 22/24. Have you got, my lord?
Yes, yes.
Then after that, What is this say? The SEBI hath categorically informed the petitioner that they had failed to provide the requisite repayment completion certificate, WR certificate. Please give it on what is they told? 4/9/24. They require only the WR certificate. Nothing, they have not told anything about that you have not given your invalid, everything. Nothing they have told. They have considered everything and called me also. And now they told WR report is not given. Please give it on 4/9/24. In reply to that, we have submitted the WA report by the chartered accountant when he has got a valid license. We are 23 to 26. So that is gone, my lord. Next question comes about the interest, my lord. I will tell details later. I will come to the interest part, my lord.
No, once the party committed wrong can be perpetuated as law. If suppose, okay, they had a meeting with you, but on that day you are not having a certificate and you submit your accounts, whatever it is. But subsequently you are not submitted the documents. So whether it can say no, you allow you to sit with a meeting and then
We have submitted the document.
No.
Let me finish it, man. Let's come to the next part is your what WR report we have submitted in time when the PRC certificate has got a valid license.
From 23 to 26.
23, 26.
So that's why I want to see
Yes,
where
ma'am.
is that?
Yes, it is there. It is there in
Show.
Yes.
That is the only question. Whether
ma'am.
in 23 you had the PS license.
Yes.
17 to 20.
23 to 26.
Where is that?
It is there
In the writ petition.
in the read petition, man.
That 20 to 23, that 3 years they did not have it.
Yes, that's something.
Coming back to
When I have given the report, WR report, my license is, I have got a license.
That's why I'm telling. That's why they're telling where is your
page 129.
one
129, annexure P16 of the writ petition.
129
Yes.
or 124.
Valid license.
Oh, but that is 124.
Yes,
124.
124.
124.
124.
And then the communication is at 126.
Pursuant to the peer review guidelines 2022 by the Council, the Institute of Chartered Accountant of India certificate is effective from 30th August 2023.
Yes.
The certificate will remain till 2026.
Yes.
Yes. Then prior to that,
But that is not that. That is the, we have applied. They have replied that the board is not able to sit because if for pandemic, it will take time. And they have issued letter. And they have considered.
just a minute.
SEBI has considered it.
Just a minute. So you come to the order, my order dated 8th of May.
Told about the validity. That's what I'm telling you. I'm replying.
No,
to you.
8th of May. My order dated 8th May. Kindly come to my order dated 8th May.
Yes.
Paragraph 3. Considering the submission made by the Land Council for the petitioner, this court is not satisfied whether from 2022-2023 there is a certificate of peer review board in favor of Messrs. So-and-so and Messrs. So-and-so. In view of the above, petitioner directed to submit certificate issued by the peer review board certifying that the petitioner was having the certificate issued by peer review board which was valid from 2022-2023.
Yes, ma'am.
The petitioners are not able to produce the certificate. The chartered accountants of so-and-so shall file their affidavit stating that we are having the valid. Where is the affidavit of the chartered accountant? Where is that?
Supplementary affidavit, my lord, it was filed.
Supplementary affidavit.
Yes.
Yeah, paragraph 8.
No, supplementary affidavit is not on record.
Yes, it was filed, it was served upon my learned friend also.
Yes.
But it is not on record.
Yes, Parag, sir.
It was served, it was filed also, man.
And we have filed a consolidated opposition.
Yes.
Yes, my lord, I have received it.
Okay, supplementary affidavit.
Yes.
Which document you are relying on?
No document, just pleadings.
Paragraph 8 of the supplementary affidavit.
Yes. I say that from March 2019 to 22nd January 22, normal functions of the company were disrupted due to COVID pandemic. Both the approved persons could not review their certificates during the COVID period, and after the COVID period is over, both parties submitted their respective reports.
সেটাই তো কোয়েশ্চেন হচ্ছে ভাই।
Yes.
My lord.
So you're not having that certificate from 19 to 2020.
Because of this reason, my lord.
For this reason.
So then if
Because
it is
during
not
that period, my lord, no peer
the
review board was
certificate is not there, how your certificate can be considered?
And but later on they have called me, discussed with me. Then they have told they are satisfied. They told you give only WR certificate.
That is your concern.
WR certificate we have given.
Peer review board is not a party here. Then I will call the report from the peer review.
We are not made impact.
Then I will call a peer review board whether you are given the authority with 19 to 2022.
And but they have written it to the one of the that it is not possible because the meeting was not held.
Then
how can it is their duty?
So if this not there, how that certificate can be taken as a lawful certificate, genuine certificate?
When my lord they wanted a WR report is most important. Winding report is most important among the all. Because
Correct.
all the documents is based on WR report.
Correct.
The WR report I have given when they have asked for, and I have got a valid license.
And that point of time we were having.
At that point of time, I have got a valid license.
No, that is correct.
Yes.
But kindly now you come to this page 75, 76, 77, and 78.
Yes.
You have issued on 18 September. Correct. 18 September you have issued this certificate. So you are 77, 78.
That is at that time there is no.
So that's why that is the crux of the matter.
That is not valid. Definitely, I am telling.
So if it is not valid
at that time,
it is not valid. So how it can be considered that yes, this is the
My lord, after the renew certificate, SEBI authority has called me, discussed with me, and told that you give the report.
I totally accept. But on that the kindly 77 to page 80. So if it is not, so how this certificate to be treated as a certificate of the chartered accountant? If it is not be treated as a chartered accountant, so how this data can be taken into consideration?
They have considered lateral stage. When after the renew, it is considered. And they want the WR report.
Where is that? Show me.
They have
They
WR report they have wanted.
Show me.
4.9. I have read
So one,
4.9.
no, last test. It is 129. Page 120.
120.
This is the communication manual.
Communication.
Yeah. Yes. Paragraph 3, my lord, of page 129. As per the page 129.
Yes.
Paragraph 3, my lord. As per
Yes.
the pro forma of the binding repayment report certificate has been duly taken by R.S. Roy and Associates, one of the peer review chartered accountants, who has submitted the same in your office on 29/11/2024. Regarding this report, I have also informed the recovery officer as
No,
well as-
that's correct. But
Madam.
you come to the page 77. As per your report, the total investors were 13,560. Correct?
Yes, ma'am.
And the number of the investors paid through the bank, 5,751.
Yes.
The number of investors by cash, 7,809.
Yes,
And total amount collected, 14 crore 75 lakhs.
Yes, ma'am.
Correct.
Total
And
Yes,
the disburse is 15 lakh, 15
15
crore,
crores, 80 lakhs.
80 lakhs.
Yes,
So,
ma'am.
so you wanted the benefit of this.
Yes.
You want to take the benefit of this.
Right.
So if you want to take the benefit of this 15 crore 80 lakhs, which you submitted, it has been disbursed.
Yes.
Correct.
Yes.
So, but if this certificate in the eye of law is not a certificate of the chartered account because he was not you have not been
Not renewed.
renewed.
I appreciate, my lord, what
If
you
it
have
is
done.
not
Yes.
renewed, so how this report is to be taken into consideration?
एक मिनट बोलो kindly comes to 124. May I just the same document which your lordship showed me, just near the middle of the page, lordship kindly sees.
Has been carried out.
Yes.
The
has
period
been-
20.
Yes, that is what I was trying to point out. So this is to certify that the peer review.
So now who
For this period.
who will clarify? Who will clarify this?
The peer review board has stated that
the peer review board has to made a party and the report has to be called
Yes.
for by
Yes.
sending the certificate, whether you
Yes,
are
yes,
the
yes.
authority
Yes.
to certify
That
this.
is the only point, my lord, that
Correct.
peer
That is
review
the
board
only
will
thing.
clarify. That peer review board will clarify.
And review board has also told
Because
that it
since
is
they have
we are
given
not
this,
we are not
You are telling, but the so you made a party, then I will call the report from the peer review board.
all right. My next point, please hear me, because next point
Next
is
point.
the interest matter. Is most vital point.
Interest,
thing that
interest will be considered unless. See, first you
Let
have
me
to,
think.
first this court has to certify, yes, the 15 crore has been disbursed.
Yes, ma'am.
Once the 15 crore has been disbursed, the question of the interest will deduce.
I want tell you why I want to impress you, my lord. How this SEBI authority, one of the government of India company, how is trying to tell all that. He says you have not obeyed.
So that's, see,
So
that's
yes.
why, yes, you are telling you are having the proper certificate,
Yes.
though it has not been issued, but subsequently it has been certified by the peer review
Yes.
board. Correct. 19 to 22,
Yes.
because of the COVID, there was no
Yes.
function. So that's why the certificate was not renewed. Subsequently, you prayed and the authority has given, the peer review board has
Yes.
been given from 30th August, but in the certificate, it is recorded 22, 23.
My lord.
Correct.
Yes.
Correct. So now, so only and they have raising the objection as per the law, as per the guidelines, this chartered accountant certificate is required.
Yes.
If who will be the chartered accountant? Who will be the member of the peer
PRC
review
board.
board? Correct.
Yes.
So then
Which
it is
has
the
been duly approved by the SEBI.
SEBI. So that's why now the peer review board is the person,
report is
is
required.
the authority, whether he has to come on affidavit. Yes, you had the authority to issue certificate on 2022.
Yes.
Correct? Yes, Mr.
I'll
That
just
is
tell
the
your
only
lordship,
point.
Lord. Well, they are taking advantage of your lordship's indulgence, my lord. They don't deserve it. I'll show your lordship why I say that, my lord. My lord, what they are saying is that two certificates have been issued, admittedly in 2022. Well, this is also an admitted fact, well, undisputed, that during the period from 20 to 23, these two chartered accountant firms did not have the qualifying certificate from the peer board. Now, when they went before the appellate security appellate tribunal, they went before the recovery officer. What prevents them? Well, if I ask this question to myself, what prevents them to approach the same chartered accountants and then get that same certificate and produce it before the recovery officer? Does anything prevent them? If the two chartered accountants have already certified.
Now, why the court is considering? Because the 2019 to 2022, there was a crucial period for the whole world.
Not till 23.
My lord,
20 to
23, that's why
23.
23 it has been given.
Yes, my
It has
lord.
been given, and the peer review guidelines is 2020 because page 124 pursuant to the peer review guidelines 2020.
Correct.
Prior to that, we don't know what was the guideline.
Right.
Correct.
Right.
So during this COVID period,
Yes.
what was the decision taken by the peer review board with regard to the chartered issuance of the chartered accountant certificate? If the whole world was in crisis.
Yes, that is required.
My lord, if I may just indicate, your lordship will see the date of the certificate is what? 2022. So COVID was over by 2021.
So that's why.
So
Please.
chartered accountant certificate was given in September 2022. So even the suo motu petition of the Supreme Court ended in March 2021. So in September 2022, first they did not have the benefit of COVID. Now even assuming that whether peer board, what was the decision of the peer board for that period, those who did not have the certificate, that is one aspect. Now the second aspect is that even when the same chartered accountant obtained the certificate in 23 to 26, he had the valid certificate, what prevented them to approach the same chartered accountant and have the same certificates issued based on, so these are certificates based on, my lord, consideration of the accounts. Whether you have paid, you are not paying me, you're paying the investors. Whether you have actually paid the investors or not, that is what needs to be certified. So if that certificate would have been obtained by them, my lord, this situation would not have arisen today. They had 3 years to do that. They had valid certification from 23 to 26. What prevented you from approaching the same chartered accountant?
At that time, we do not know that was required.
What is he saying? I'll show your lordship 7 orders. They went before the appellate tribunal. Appellate tribunal told them, please go back and satisfy the recovery officer. Kindly, my lord, I can show this from my opposition. Have annexed all the appeals that they have filed. My lord, they have filed at least 6 to 7 appeals from the order of the recovery officer. And in each time, they have been told by the appellate authority that go back before the recovery officer and satisfy the recovery officer that payments have been made in terms of the order of May, which is the principal order under section 28A, where they have been held guilty or they were required to pay. So, my lord, this fact,
August 2020. No, May.
May, my lord, subject to correction, it was in May. Order May. 12th May 2016.
2016.
Yes, 2016.
So that's the principal order which they are required to comply, or they are trying to comply. So so today, what is the recovery officer doing? In terms of that order, he is trying to attach, they have attached the bank accounts in respect of which they are aggrieved and before your lordship.
Yes.
So now in the writ court, how would the writ court determine it? There is a separate body sitting for the purpose. So you go and satisfy the recovery officer.
Yes.
And if you are aggrieved by the order of the recovery officer, like they have on multiple occasions carried the orders of the recovery officer because it's an appealable order under 15T, before the appellate authority, they can prefer the appeal. Why would they require the writ court to go into these disputed questions of fact?
Yes.
And my lord, in any event, if your lordship will see, there is a specific efficacious remedy available to them under section 15T of the Security Exchange Board of India Act, which specifically provides that if they are really aggrieved, they can go and appeal. So, but in order to resolve the issue, since your lordship had entertained, so we have also indicated in an opposition, my lord, the step by step, my lord, that they have not been able to satisfy the fact that the payments have in fact been made to the investors.
No, not at all, not at all. Yes. Fine.
Now, of course, he'll say not at all. I'm sure he'll not agree with me.
We are complying with that.
None of the orders have been complied.
We have complied with that.
Okay, then you go to the appellate authority. You go to the appellate authority and satisfied to the appellate authority.
My lord.
Challenging the
No,
record.
no, I'm
Page gulo bolo na.
permitted to waste
Yeah,
about
right.
1 minute time. I have gone to the appellate authority against the recovery. They told, the chairman asked me that as per the act, I have got no power to interfere in the recovery of this. So you,
the order.
You
Where
go
is
for
there?
it.
Page
There is the order.
And
104.
withdraw
Page
the appeal.
104, my lord, kindly see.
My lord, kindly see the appeal orders which I wish to bring to your lordship notice.
Okay, then I have to hear the matter on.
Very well.
which
Kindly
we
fix
dispose
it
of.
on any day convenient to you.
My lord, one thing. About the interest part. My lord, seniors, I've got great respect to it. I think they have misguided him. Total interest calculated by WR report. WR report, whatever.
Sir, that's why I am again and again telling you with regards to the interest, unless and until you will not satisfy that the 15 crore has been disbursed.
Let the first
I
part,
have
first part
in
again.
extra statement, my learned friend can go and consider the total outstanding due as on date 139 crores.
That's I'm telling you. That's I'm telling you.
Telling who?
The interest part. Sir, my lord, kindly come to the order of.
There is an order
My lord,
which you have accepted. So the interest is
So
completed
what-
based on that
what the-
order.
What is your contention with
My
interest?
interest is that on 2054, on 2015, I have attended the SEBI member. I have myself, out of 15.61 crores, by that date, I have paid 4.10 crores. That is written in the order sheet.
So what is the remaining?
Then pending is 9.51. And 9.51 I have paid during
18.
13 to 18. So there is only 3 years. I have taken an oath in the court on this court that I will pay the amount. My lord, total 113 Punji farms in the country, except my client, nobody pays it. I have paid in full. All right. My lord, one thing.
The petitioner has filed written notes of argument and submit that he will not use affidavit in reply to the affidavit in opposition filed by the respondent number 3. Let the written report and the affidavit in opposition filed by the respondent
Final
number
hearing of the
kept with the record.
So they are from-
This is the matter. Give the date for hearing.
Have not been served with the copy of the supplementary.
Give the supplementary.
Very well, madam. We will.
8th October, 2 p.m.
8th October 2 p.m. लिखे रखो। क्या ना तुम्हें नहीं?
Date 10, yeah. Date has not been given.
How can he disburse the money?
No, he is not disbursing. They are asking for the disbursement.
No, my lord, this money, the attachment of the account, this money has to be paid back to the investors. So, my lord, recovery officer's duty is to recover money and pay to investors.
That's
Not,
why he's telling.
yes.
That's why he's telling.
Yes.
He's telling that the recovery officer wanted to withdraw the amount for disbursement.
So that is the job of the recovery officer.
No,
But
he's
that he has to
telling that
hold the money till the matter is
because they are
pending.
telling they have making a request to the bank not to disburse because
Yes.
of the pending of the suit.
Yes, madam.
Pending of
I'll tell you, Lordship, my lord, today what are they saying? They are saying repayment. They are saying principal repayment. The interest is in excess of 80 crores. So if today repayments are not made, who will suffer? The investors will suffer.
investors.
So then that's exactly what they want. So
What
they,
amount
it is.
due and what is payable towards interest. But that your lordship decides first and then my lord.
Okay, come on 8th October.
Very
8th October. 8th October 2 p.m.
But opposition, a reply?
Yes.
there?
Call the
Reply,
pastor.
My lord,
Give an opposition reply. We will give also reply.
no, we will give the reply then, my lord.
That's why I told you, Lordship, that kindly record that they should wish to file a report.
I already recorded.
No, my lord, kindly do not record that. Kindly do not record that. But that will, they may. it may
Initially, yeah, the court has asked, the other side has asked, you told that you will not use the affidavit in reply.
I say my allegations goes uncontroverted. Now they are saying
We
reply.
have
Affidavit in opposition, written notes of argument filed with the
बोला?
petition,
अरे
respondent number 1, 2, 3
First,
filed
okay,
affidavit in
नहीं
opposition.
बोला.
Petitioner prays for time to file reply. Let the reply be filed within 2 weeks after serving the copy. This is the matter.
Grateful.
Yes.
Oblige, your lordship.
Grateful, my lord.
Oblige, your lordship.
I'm very obliged.
Yes.
I'm appearing on behalf of the petitioner, my lord.
Yes, what is the matter?
The petitioner successful in joint entrance examination, also in NET, National Eligibility Entrance Test.
National
Eligibility in
NET.
NET. In entrance, you have also
MBBS.
or
For MBBS.
for MBBS.
Yes.
My lord, the thing is that my lord comes to page 12 once.
Yes.
This is her voter ID card. She cast her vote in this last elections.
This voter card belongs to whom? Petitioner.
The petitioner.
Okay.
Page number 14 is her birth certificate. She belongs to scheduled tribes in as Munda. Certificate is on page number 15, my lord.
Yes.
And the next annexures, page number 16 is her father's West Bengal Medical Council certificate. Her father was also a doctor who died in 2017.
Okay.
Now, kindly, my lord, page number 18, the appearance, admissions for the joint entrance examinations, also and National Eligibility and Entrance Test 2026. In joint, she also successful at that point of filing. NET result was not published, and she also succeeded in NET also. My lord, page number 24, the page number 22, annexure P4, domicile certificate was issued in 2024 in her name by the authority.
Yes.
The very next page, my lord, 23.
So this certificate is valid up till what? 1 year?
1 year. 23, the block development officer send a letter to subdivisional officer for regarding police verification report. Unblemished police verification report was submitted along with all documents, my lord.
Yes.
The next page 24 was the police verification report, my lord. This is the now this is the terms. Without the domicile certificate, she is not able to take place in any of the counseling process, my lord.
Yes.
I'm only for before my lord, only to issuance of the domicile certificate, as because
for the domicile certificate, what are the document is required before the authority?
all the papers.
What documents the authorities are considering for issuing the domicile certificate?
In this case, only as per they have stated, not in written, that her mother's name was.
Where is that? They have issued any order?
No, my lord. That is only her. I have annexed that.
I am for the state lordship. As per her mother name is deletion from the electoral lordship. That's
But
why
her name is in the voter card?
no, her name is not.
What is that? Can you see page number 14?
12.
12?
Lordship, kind.
She has casted
Let me
vote.
Yes, as per my instructions. My
Can
lord,
you see the page 12?
also in page number 35, her mother also filed the appeal before the trial.
That is different.
35.
Mother's name has been deleted, but the
Lordship.
father was the doctor.
But at present
He died, but it is not a dispute. She is not a daughter of the.
No, not
deceased,
no.
correct.
Yes,
And she was residing. And for the domicile, whether you have a landed property.
In my name, I don't have.
No, not your name, your father's name.
No.
Where you resides? In your property or in a rented property? Have you disclosed that you have a landed property in the name of the father?
My lord, that is page number.
What is the procedure adopted by the state authority for issuance of the domicile certificate? What is the procedure? What is the guidelines?
That is page number 33, my lord. The land.
What are the guidelines? For the domicile certificate, the petitioner has to prove whether she got birth, the place, she having the birth, if it's age, if they are having the certificate of the residence of the completed the education on the said area.
He must be a citizen of this. He must be a resident of under the jurisdiction of the place, and he or she must cast vote or
correct. So if they with the other
and issuing her birth certificate or else anything, Lordship. But as per the current situation, Lordship, her mother name is not.
Mother name is deleted,
Lordship,
but
that's why
she is not asking for the domicile certificate of the mother.
Lordship, that's why we told the.
She is not asking for the domicile certificate of the mother.
Lordship.
Correct. She is asking the domicile certificate for herself.
Lordship.
Admittedly, she is residing there in Bankura.
Lordship.
Admittedly, she has education in the said schools. She has appeared in the NEET. She cleared the NEET. So that's why I'm asking, what are the guidelines for consideration of issuance of the...
As per my knowledge, at this present, I have no instruction, but as per my knowledge, he or she must be a resident of the jurisdiction of the state.
That the police has given the report.
Yes, Lordship.
Police already.
Just I go through the brief, I saw that, Lordship. As per Lordship direction, if Lordship directed us, then
My lord, page number 24, my lord.
we have to comply as per Lordship
My
direction.
lord, page number 24.
Yeah. Class 1 to class 12, where you have resided? Which school? You persons are also not preparing the writ petition properly. You have to prove, sir. First, you have to make an averment. You got born in so and so area. You have completed your education in so and so area. Your father is having the landed property. You are residing there since birth. Where is all pleadings?
That's because her father.
That's why the government authority is not able to say what are the guidelines they have adopted.
Her father was a doctor, my lord.
Father was a doctor, might be in America, might be in other places.
Transferable, as per transferable job, my lord is correct, my lord.
That's what I'm telling. Domicile is smart.
Last residing. Where
domicile, some of the state, the domicile they considered the regular resident of 10 years. Some state they considered since birth. Some state they considered regular 10 years education. What are the guidelines? I am for the last 1 year I am dealing with that, but till today nobody has produced the guidelines with regard to the domicile. What are the guidelines for issuance of the domicile certificate?
Well, she is residing there and with her birth in Bakura at her mother's place.
You come on Monday. Come on Monday. I am keeping it. And you also come on Monday, take instruction. You come with the guidance. You come with Monday. Whether the father was, they might have been deciding. The doctor might have been purchased the property.
Whether on Tuesday can it be possible?
Okay, no problem. As for you are come with the total. If you want, you file a supplementary affidavit disclosing all this. First of all, your all education, which school, where you resided, when father died, all the details. Then I will pass an order so that.
On Tuesday, mother.
The Land Council for the petitioner and the Land Council for the state press for time to take instruction. Land Council for the petitioner also press for time to file supplementary affidavit disclosing the document with regard to the all educational certificate from class 1 to class 12 and whether the father of the petitioner has any residence, had purchased any property or inherited any property in the said area. Let this matter appear on 25. Within 5 minutes.
My lord.
Next.
For the petitioner in this matter. This is a matter, my lord. Petitioner is a contractor which produces the dolomite and the magnemite and the limestone. And they entered a contract with the private respondent who is a central public sector undertaking, a subsidiary of Rashtriya Ispat Nigam Limited. No matter what has happened, my lord, my scope and area of work is only to produce limestone and extract dolomite, crush them and load them upon the railway wagons. Now, my lord, they entered a separate agreement with the railways for the purpose of transportation of those finished products which are dumped by me to their own destinations. Now, what has happened, my lord? There was a derailment. Now, the derailment occurred due to poor maintenance of track. I have nothing to do with, my lord, transportations of goods. My only job is only limited to the extent of dumping the finished products or loading the finished products in the wagon. Now, my lord, the railways and the private respondent, my lord, they formed an inquiry committee, and the inquiry committee exonerated me. Just a minute. A inquiry committee exonerated me from all the charges. I have nothing to do with the derailment. My lord, if your lordship kindly see, then what happened, my lord, subsequently, my lord, the private respondent number 5, who is a central public sector undertaking, wrote a letter and said, you also have to bear the expenses of derailment, and accordingly, 1 crore 7 lakhs will be deducted from your security deposits. And that too, my lord, without giving me any opportunity of hearing, without, when there is no wrong attributable on my part, I have not done anything. There is no nexus with the scope and area of the work. If your lordship kindly see what is the report, page 64 for once.
What is the grievance?
My grievance is this, my lord, without due process of law, my lord, when it has been categorically stated in the work order that there will be a proper inquiry investigation, then without conducting that, they cannot arbitrarily impose this punishment upon me and recover the amount. Kindly
Where is the impugn order?
Kindly come to
order dated 3rd March 2026.
64. My lord, kindly come to page 64 for once. It will be very clear what has happened actually. My lord, this has been referred to the railways by the private respondent, and it says that, my lord, my lord has found.
Yes.
Wide our above referred letter under reference such and such BSLC had requested for revision of derailment amount levied on us due to the following.
Who has written this letter?
This is written by the respondent number 5
Yes.
to the railways. The actual cause of derailment. There was heavy downfall rain during derailment which had caused inordinate delay. Not only these, in the course of derailment, 3 more wagons got derailed due to heavy rain. The main cause of accident is human effect mistake, which is clearly established in your inquiry report. That is the inquiry report of the railways. The derailment charges levied are mostly for the labor component, which is more than 60% in the entire bill, and is also because of the act of God and heavy rain. In addition to this, there are several other reasons like long pending CTR work for entire CTR was scheduled in 2019 and got delayed due to various reasons attributable to both railways and BSLL, that is private respondent. Only BSLC mainly due to lack of resources funds as the company is reeling under acute financial crisis, due to which BSLC paid its share to CTR funds on installments. My lord, from these report, it appears that I have nothing to do with this. It happened for something or other reasons. Now, my lord, kindly come to the impugn letter at page 66. Now, which I have been made the scapegoat, and where I don't have any nexus, I was imposed with the punitive charges that I have to pay it. Kindly come to page 66. My lord, it has been written to me by the private respondent. We acknowledge the receipt of the above referred letters from the railways regarding the derailment of goods train and subsequent imposition of charges thereof by the railways amounting to total amount of 1,66,000. As per clause C and P and Q of the work order dated, it is expressly stated that contractor shall be responsible for any damages or loss arising out of the operational, including derailments. The clause clearly mentioned that the contractor shall bear all expenditures related to such incidents. We would like to clarify that in no way you absolve yourself of your responsibilities as wagon loading contractor. The term of the work order are binding, and it's your responsibility to ensure that all operations are carried out safely and efficiently. Now, my lord, kindly see what the clauses which they are relying upon. If your lordship kindly come to the work order at page 40. My lord, if your lordship kindly come straight away to the clauses which they have highlighted, that clause 9, page 40 of the work order of the writ petition.
Yes.
Clause 9, lordship has found. N. Clause 40. N. Clause N.
Yes.
You must ensure smooth movement of rakes in the railway siding by proper cleaning of track. My lord, kindly see my scope. Bush cutting and clearance of railway track and siding. All spares for track maintenance. Now, my lord, this is kindly, it has some importance. Except slippers and rail as per requirement will be borne by you. Now, my lord has seen it is because of poor maintenance of track. Now, kindly come to clause P. The charges levied by the railways in case of derailment, wagon damage, or any loss of railway property due to jamming of railway track or uneven loading or any other act by you will be borne on your account. My lord, the inquiry report does not say anything regarding these. Inquiry report clearly says that it is due to the act of God, heavy downpour or rain, and there is a poor maintenance of track. So, and also, my lord, from the work order, it will clearly appear at page 56 that before imposition of any penalty, page 56, my lord, kindly see.
Yes.
Lordship has found. The penalty shall be decided after investigation and obtaining the report either from engineer or from the committee, if formed for the same. The penalty shall be decided by the business head in consultation with engineer and will be deducted from the other bill. Now, they have not conducted any of those inquiries. And so far as the probable punitive clause is concerned, there is not a single clause which says that they are entitled to take derailment charges from me. It's absolutely contrary to the work order. It does not have any clause so far as derailment charges are concerned. And even if there is such an action, that has to be preceded by a proper inquiry, and I should be called for a hearing. Well, this is a classic case when that I am convicted of a murder, I am exonerated from all the charges, subsequently I am hanged. This has happened to me, and this has been done by them, my lord, without taking into consideration all my actions. I have nothing to do with this.
Yes.
Not a single word has been spoken against me, but
Yes.
they have deducted 1 crore 7 lakhs. I only beseech your lordship, let that amount be deposited with the registrar general, because they have no authority to deduct. I could have appreciated, my lord, they had any authority, but they have no authority here.
Yes.
This is my only case.
Lordship will permit me to file an opposition to the petition. I have been served recently, Lordship.
No, I have served long.
No,
long.
I have been
You are
instructed
appearing
that
for
the-
whom?
for respondent number 5, Lordship.
Stone.
Yes, now, Lordship, what appears from the records, Lordship, there are clauses in the contract. My learned friend is disputing the very action of one of the parties to the contract. There are disputed questions of law as well as facts. There are clauses in the contract which entitle me to deduct money from the security deposit on the ground of charging penalty. That is also there. I shall show from the agreement.
But the kindly,
The reason-
once your report is otherwise.
Lordship, now coming to the report, Lordship, the page that my learned friend has shown is not the report. That is a correspondence between the railways and the respondent number 5. Now, there is no if I understand my learned friend's stand is that there is no finality. If there is any finality, that should have been coming from the railways. If a decision is taken by the railways, my correspondence, what appears from the correspondence Lordship has seen, is a question.
Because
is
as per your report, the derailment and all these things, that was the act of God.
Lordship, that is not a finding. That is something we had submitted.
That's why you have
this is the reason.
submitted. Yes, taken the specific, because where is the committee report?
Now, Lordship, the committee report, Lordship, that I shall take instructions, but Lordship will also appreciate the clauses in the contract entitles me to deduct whichever amount that has been imposed upon me by the railways. I am entitled to deduct from
There's
the
no
wagon owners.
problem. Deduction is no problem. First, you have to prove with regard to the negligence of the petitioner. Yes, due to the negligence of the petitioner, there was a derailment.
Yes,
And
my
for the purpose of the derailment, the authorities have assessed the amount, so and so, so and so. That's why, being the contractor, he is liable to pay under the contract.
Lordship,
This is the law.
that perhaps is the railways call.
That is
Lordship,
the law.
that is, yes, my lord.
That
But
is the law.
is
You
the
have
railways
submitted
call.
the report. Now the committee has to be seen whether there
My
is
lord.
a negligence on the part of the petitioner's contractor or not. Yes.
Lordship, that is, Lordship will allow me to file an opposition. That
No,
is
that,
all.
let me see. Let
Very
me
well.
see.
Admittedly, the incident of derailment was happened.
Correct.
And at page 40,
Hmm.
clause P and Q,
Hmm.
my lord, they have the authority to deduct this charge.
Correct.
That has been debited from the petitioner's account.
Correct. I am not on that. The court is totally agree with the terms and conditions. That's why I have already stated. If derailment, there is no denial, he is not a contractor. He is a contractor, there is no denial that he is liable to pay the compensation if derailment has been occurred due to the negligent on the part of the petitioner. Now they have submitted, the respondent number 5
That
has
is,
submitted.
my lord, in respect of that, my humble and respectful submission is that when the question of derailment has been happened and due to whose negligence that was done,
Correct.
that is a serious disputed question of fact.
That is the evidence.
That can be.
That's why I'm telling, if you have come to the conclusion in the committee report, then nothing to do by this court. If you are telling that still, because you have concluded and you have imposed the fine, deducted the amount. So that's now, if you have submitted, you have concluded the inquiry and come to the conclusion, then if it has come to the conclusion, then it is to be decided. Let us see what is the procedure on that. So he is telling that because his contention is now, you come to.
What is the detailed report?
Yes.
That is not with us.
Correct.
My lord, prior to that, my lord, kindly consider one thing. That is, my lord, the page.
Kindly come to the page 56.
Page 3.
Page 3.
Paragraph 1.
Yes.
On the first line, that the petitioner number 1 is a partnership fund, being a legal entity and being lawful contractor engaged with a business mind.
Correct.
My lord, according to the section 69 of the Partnership Act, if the fund is not registered, that is the fund.
Yes, that is the.
And my lord, I have not found anything, whether my lord, the fund is registered or unregistered. 69, my lord. And my lord, apart from that, my lord, kindly see the incident.
Yes.
That is a bar. And apart from that, your lordship, admittedly, the entire, although my lord, the registered office, although the headquarters of the Zonal Railway of the Southeastern Railway, that is at Lajunji, that is within your lordship jurisdiction. But my lord, the material cause of action or the incidental part of cause of action, that is my lord, within the Chakradharpur division, and the derailment incident was also happened, my lord, the outside the territorial jurisdiction of the company. So that portion is admitted. And my lord, at this stage, that is my true submission. And my lord, when my lord, the admittedly the incident of derailment has been happened, my lord, kindly consider the page 40, clause P and Q, my lord. Page 40, my lord, P and Q. The charges leveled by the railway.
Yes.
In case of derailment, wagon damages, or any loss of property, railway property due to jamming of railway track or uneven loading or any other act by the you will be on your account.
Correct.
In case of derailment of wagon and or engines at any place of railway track, Gandhi Road to Munipara under BSLC jurisdiction, all charges they will impose by the railway towards derailment, wagon damages, engine damages, overhead electric, OEG, lines damage and track damage and restoration shall be on your account.
Correct.
And my lord, in compliance of this clause P and Q.
So that's an
Yes, that is
see, the court is not denying you are not the authority. You had the authority, but you cannot by closing your eye when you pass an order for you have to some law. How you are assessed? There, yes, where is the registration?
My lord,
Under the partnership?
it is there, my lord.
Where is the partnership registration? Otherwise,
all are petitioners before your lordship.
Petitioner, but you are filed as a registered partnership firm. It is not an individual. You are telling that you are the partnership firm.
My lord, kindly see the power of attorney I have annexed.
Sir, power of attorney, kindly come to your paragraph 1. The petition number 1 is the partnership firm. Partnership firm,
I will use the supplementary affidavit. I will annex that.
Yes.
I will annex that, my lord.
Okay. So you file the report when you file, and with regard to the cause of action?
Cause of action, my lord, the agreement was executed here in Kolkata. Kindly see. Work order. Page 34, my lord. And petitioner also is having his registered office here. Kindly see the last bottom left. Registered office, Shourab Avashan, Sector 2, Salt Lake City, Kolkata 91.
That is when the communication. Kindly.
How soon you file the both you file report? How soon you file the report?
My lord,
Come with
better, my lord, may I submit one thing? My lord, we shall come with the detailed report. That affidavit in opposition, annexing there with the report.
That's I'm telling. When you will file? 2 weeks?
Lordship, 3 weeks.
My lord, I think.
My lord, in the meantime, my lord,
yes,
kindly restrain their hand for certain period of time. They are
for what?
Not to take any coercive measures.
Already deducted. Already deducted.
Portion deducted, I was told, not the
No.
entire amount.
Can you see the April 2026? Now we are in August.
Page 69, you fellow.
Yeah, April. Now we are in August.
Okay.
It is not an immediately. If it could have been immediately, it can be. The respondents have the respondent number, your railway. Which respondent you are appearing?
1 to 4. 1 to 4.
1 to 4, my lord.
Respondent number 1 to 4. Raise the preliminary objection with regard to maintainability of the present date application on the ground that in paragraph 1, the petitioner has stated that the petition number 1 is a partnership firm, but they have not disclosed any registration of the partnership firm, and thus the writ petition is not maintainable under section 69 of the Indian Partnership Act. The second point raised by the respondent number 1 to 4, as there are no cause of action arose within the jurisdiction of this court, and thus this court is not having the jurisdiction to entertain the writ application. The respondent number 5 raised the objection with regard to maintainability of the writ application that there is a disputed question of fact which cannot be decided in the present date application. The counsel for the petition submitted the petition is having the partnership registered partnership deed, and he will disclose the same. As regard the cause of action, he submitted that the work order was executed at Calcutta and the registered office of the petition is Calcutta, and on several correspondence have been made between the petition and the respondent is Calcutta. As regard the disputed question of fact, this court finds that an affidavit is required to be filed by the parties to ascertain whether the fine imposed, the impugn order passed by the respondent authorities are in accordance with law or not. In view of the above, the respondents are directed to file affidavit in opposition, disclosing all the documents within a period of by 3 weeks. Reply, if any, there to be filed within 2 weeks.
2 weeks, sir.
2 weeks. Full stop. List the matter. On 24th of September 2026, under the same heading, the maintainability of point of maintainability raised by the respondents kept it.
My lord,
open.
I will annex all the documents so far as the partnership deed is concerned in the affidavit in reply. All these documents.
Discuss that.
Lordship, instead of 24th, can it be 25th, my lord?
25th,
my lord, next.
Okay, 25th.
Lordship, maybe a time may be fixed, my lord.
Come on that day. Let I will see.
I'm great.
Next.
My lord, in item number 19, I beg to appear for the petitioner, my lord. This is my affidavit of service. My lord, I have been issued a work order in terms of a notice inviting tender, my lord. I have completed the same. Thereafter, work completion certificate was issued in my favor, my lord.
The work order was issued.
My lord, work order was
Where
issued.
is that?
My lord.
37 ki direct bol na ji. Okay.
My lord,
completion certificate. He has already issued completion certificate. There is no dispute. Come to page 37.
Yes, my lord. 35 is the work order, my lord. And
Completion
37 is the work completion certificate. Thereafter, I have
37 completion certificate is there.
So.
Where is the bill?
My lord,
What is the total bill amount?
my lord, in page number 37, in the bottom portion, if your lordship kindly comes to paragraph 3, my lord, there is an outstanding due of rupees 17 lakhs 36,668.
May I suggest one thing? My lord, kindly direct the SDO to submit a status report. Why they are not withholding the
I
payment?
am disposing.
Yes.
The finance secretary is a party here.
No, my
Secretary
lord.
finance is a party here.
Finance secretary is not.
No,
a
my
party.
lord.
District magistrate is.
District magistrate is the.
Who will sanction the amount?
My lord, district magistrate will sanction the amount in favor of the
don't
block
think so.
development
17
officer.
lakhs. The district magistrate is not having the authority.
Lord.
It is a finance secretary finance.
Secretary finance, my lord.
Okay, I am disposing of. Recorded now. I am disposing of.
My lord.
The grievance of the petitioner in the present writ application that the block development officer, comma, HC4-1 Malda had issued the work order to the petitioner for infrastructure of DCRC oblique counting, including temporary stall pandal, electrification, sound system, civil work, supply of various articles, etc. ICW WB PGE 2023 at Harish Chandrapur-1 development block on 26/6/2023. As per the work order, the petitioner has completed the work, and after the completion of the work, the block development officer has also issued the work completion certificate on 2nd September 2025, certifying that the petitioner has carried out the work as per the sanction estimate and plan, and there is an outstanding due of rupees 17,36,688. Counsel for the petitioner submit that in spite of the admitted amount of rupees 17,36,688, the respondent authorities have not released the said amount. He further submit that the petitioner also made representation to the authorities for release of the amount, but the same has not been released. And counsel for the respondent submit that if a direction is passed, the authority will consider and will take appropriate decision with regard to the release of the amount. In view of the submission made by the counsel for the parties, writ petition is disposed of by directing the district magistrate, directing respondent number 2, the district magistrate and collector of Malda to consider the request of the petitioner with regard to release of the payment in terms of the work order dated 26/6/2023 and the work completion certificate issued by the block development officer dated 2nd September 2025, and to pass appropriate order for release of the said amount in favor of the petitioner within a period of 6 weeks from the date of receipt of the order.
My lord. Grateful.
Next.
This matter has been assigned to your lordship, my lord. It pertains to police inaction.
Lord, item number 20, my lord, I am
Releasing. Assign here?
Yes, my lord. It has been assigned to your lordship,
my lord, I am for the private respondent, my lord, led by Mr. Saurudipto Banerjee, my lord. My lord, kindly fix it at 2 p.m.
My lord, the petitioner before your lordship is the proprietor in respect of a shop room, in respect of which he is a tenant there since 1989. There are certain civil suits are pending between the parties regarding eviction and ejectment. But what had happened in the year 2013-14, an endeavor was made on behalf of the landlord to obtain a decree against a dead person, that is the erstwhile tenant of this in respect of the premises. He obtained a decree and attempt was made to evict this petitioner. So this decree was challenged, 340 proceeding was been filed. Subsequent thereto, he could not execute the decree and everything, and the landlord could not execute the decree, and the civil suit has been going on.
The tenant.
Against the tenant, and the civil suits are going on. So repeated endeavors are being made, sending the goons and the persons in their shop room for using the law of the land, for using without having regard to the law of the land for forcefully evicting them. The last incident, if your lordship kindly came to page 56
Suit
of
is
my-
pending.
So let's suit is pending.
Who has filed the suit?
The landlord filed the suit, my lord.
You are the tenant.
I'm the tenant.
So why you not moved the order 13 and rule 1 for in temporary injunction? Why you not move the application before the civil court for temporary injunction?
My lord, we have filed the application, but that is after that this has happened. This has recently happened on 17th of July 2026.
Correct. It might be a happen. You might have been given the complaint, but you could have been approached the civil suit and got an order of temporary injunction.
Well, I can do that, but lordship would kindly appreciate.
What the court will do?
Well, kindly appreciate. But this is a something which is using a force of law without the having regard to the provisions of law. Civil suits are pending. He can obtain a decree. The civil suits can come
Not
to an end.
obtain a decree. Civil suit, complaint, tenant, defendant, landlady or landlord, whatever it, they are harassing you, sending a goons and whatever it is, you go and take an interim order from the civil
144
court.
proceedings are also pending. Millet.
The settled law. You cannot be evicted without the due process of law.
Absolutely, Millet. But this process also cannot continue. Millet. This makes out a cognition of the cognizable offense.
Yes, who is appearing?
Well, I am for the private respondent. Kindly fix it at 2 p.m.
Who is for the state?
And for the state law.
Yes.
It's a report regarding this matter filed by the police station.
What is the report? What the police says? There is any incident?
Civil matter.
Civil is okay. What about the allegation?
Lordship,
Sending the goons to the shop room or the premises for
Lordship, the
evicting.
single document is the order of the proceeding of 126 and 163 proceeding was pending, and this is the order of the learned magistrate lordship. If your lordship kindly comes to the
Executive
second page.
Metropolitan Magistrate.
second page, second last paragraph. It is stated.
That's it.
Yes, give the copy.
Doesn't contain the
The second last 3 paragraphs. See, there is nothing.
Well, your lordship is referring the order dated 28th of July, Millet.
No, not the police report. And magistrate report, yes.
Millet.
Before the magistrate, the SI has submitted the report.
Well, that was submitted long back. That was subject to correction. Millet. It was submitted sometimes in the month of June.
Yeah, June 26.
June 26.
Yes.
Well, this incident pertains to on 17th of July. So, well, subject to correction, the report dated 28th of July 2025 will be relevant.
There is a complaint, 17th July.
Well, your lordship will kindly come to page 54.
Yes, 54 is there.
Yes, Millet. The relevant portion will be page 56. Lordship would kindly consider the last 2 paragraphs.
Yes.
And if your lordship sees the report dated 28th of July 2025, well, I am not getting any reference so far as the incident of 17th of July 2020.
Can't be.
Well, this
That can't be.
well, it's a well, kindly it's the order report dated 28th of July, Millet.
Yes.
28th of July, second report. My lord, it doesn't contain any reference of 17th of July, although on my call, on my telephone on that day, the local police station was present, and Lordship would kindly appreciate this is a market area.
বলেছি রিপোর্টে রিপোর্ট কিছু রিপোর্টে শুধু 144 এর আপনার এটা সিভিল ইংলিশে সেটা লেখা আছে রিপোর্ট
Yes.
At least they
But in your police, the present report dated 28th of July, where is the reference of the complaint of the petitioner, which was made on 17th July? Kindly come to the page 54. Kindly come to.
It is written that it is pertinent to note that the allegation of the petitioner.
Correct. But kindly come to the page 54. Page 54 of the writ petition. Correct. Of the writ petition. On 17/7 there is a complaint. Where is the reference on the this complaint of 17 July?
Lordship, this report is made on the basis of this complaint because it is the report dated 28th of July 2026.
That's why I'm asking.
It is after the complaint. If your lordship comes to the second report, lordship, written that the allegation of the petitioner that the respondent number 6 and his main and agents came to the shop of the petitioner at the address physically and created disturbance would not be substantiated.
Correct.
That's the inquiry, lordship.
When they went, when they inquired. That's why police must be, there will be GD, there will be inquiry date.
Not written in.
So, it is the replica of the earlier report. He must say, no, yes, sir. They have received the report on complaint on 17/7/2026. They went to the spot and found nothing was found, or the allegation is not substantiated. Where is that?
It is not mentioned.
Then, yes, Mr. Bani, what your clients are doing?
But my clients are doing nothing. They are pursuing an eviction suit. In the eviction suit, same application has been filed, but as what is there in the writ petition. But same application for injunction, I have a copy of that. They are asking for the same order. 2101 also pending. This is the prayer before the small causes court where the eviction suit is pending. Same averments, everything same, restraining him from disturbing the petitioner. That is pending. The averments are also same.
See, if anything is order is passed in the writ petition, your injunction will be defeated.
But not only that, there are other things also. Malad, they lodge the complaint before the Park Street police station. Malad, kindly comes to page 54.
Yes, I am.
And they say that the property is under New Market police station. But kindly see how this is possible. Given to Park Street police station.
Well, probably the recently the jurisdiction has been changed, Millet. Initially, it was under the New Market police station. Now it is under the Park Street police station.
But there has been no change.
Had it not been the situation, the police station would not have received this report. And this report, whatever has been submitted before your lordship, that would have been.
Okay, you do one thing. Come on Tuesday with the report with regard to the 17th August. What is the report? Come with the report. I will discuss.
But there are other points also. I would reiterate before your lordship.
Let the report.
Only on 28th, if your lordship be kind. 28th.
The counsel for the state has submitted the report, but this could find that in the report the police authorities have not dealt with the complaint filed by the petitioner dated 17/7/2026. Accordingly, the petitioner, the state authorities are directed to file a press report dealing with the complaint filed by the petitioner dated 17/7/2026. Let the report be filed on 28th. This is the matter on 28th.
Extremely grateful, Millet.
Yes, next.
Today is the date for next. Sorry.
Well, this is the matter, my lord, which I was appearing for the petitioner. I argued, then, my lord, I handed the baton to my learned junior, Now, my lord, unfortunately, my learned junior is not today because her mother has suddenly fallen ill. Be that as it may, my lord, today I want to conclude, my lord, had asked for a notes of submissions. Now, lordship will kindly allow me just 2 minutes time as far as my notes of submission are concerned, my lord. My lord, three things had fallen from my lord. Since I was the person who started initially, just 2 minutes by the clock. I know SIR matters will begin at 1.
No, no problem.
Now,
SIR will continue.
Now, my lord, what had fallen from my lord remembers it like the back of the hand. We are all on the report of the competent, where she said that the election process, pre-election process were faulty, but the election was carried on perfectly. One, and my expulsion was illegal. Now, my lord, they came up with a particular exception to that. Now, lordship will kindly see what has happened. Initially, when I was expelled, I made several representations. Several representations were made, but competent authority did not take it into consideration as far as my expulsion was concerned, my suspension rather. Now, in the meantime, they circulated on 25th of June. Lordship will kindly take their exception just once.
Which affidavit in opposition?
Yes, they have taken out an exception.
Exception?
Yes, my lord, taken out by the private respondent, which was filed on, lordship, it is affirmed on 13th of July 2026, the last pleading by them, that is the respondent authority, 325. My lord has got it.
13th of July.
13th of July affirmed affidavit in opposition on behalf of respondent number 325. Exception taken to the report filed by the competent authority. When my lord was pleased to ask them to show reasons. My lord has got it.
Yes.
Now, my lord, this is the exception. The first annexure is at page 6. This is the elaboration of the order which I challenged. Elaboration is, Annexure A, the election committee was constituted without any resolution or decision being taken in the duly convened board meeting, SGM or AGM. Second is, proper notice of election was not published. So my lord said that you file an exception. Now to that exception, they have come up with Annexure B, that is page 7. This was the cause of action for my first writ petition. By that time, election was not declared. This was on, according to them, this was on the 25th of June. After that, I came to this honorable court, and by way of my first writ petition, I challenged 2 points. Not only my suspension, but also the election process. Now, lordship will kindly come to their affidavit in opposition. Just 2 minutes by the clock, my lord. Whatever has fallen. Affidavit in opposition, my lord will kindly come.
Yes.
My lord will kindly come. Lordship will kindly come to affidavit in opposition, the pleading, page 7. Vis-a-vis, my lord will keep both the documents there. Page 8 of their exception, page 7 of the opposition.
Yes.
My lord will kindly take up paragraph H. Their opposition, the private respondent, 325. State has, competent authority has not filed any opposition. Page 7.
Yes. Page 7.
Lordship.
Yes.
Now, lordship will kindly see I. As number of vacancies were 48, and there were only 31 eligible candidates contesting. As such, the said 31 candidates were declared as successful by notice dated 14/7/2025. Honorable High Court's order was passed on 18th. There they did not come and say that the selection has already been done. So that this is pre-election process.
Yes.
because election were declared on the 20th.
Yes.
Order was passed by this honorable court on the 18th of July.
Yes.
On 14th, they have declared that election is complete because 31 candidates. So therefore, and without any AGM, without any SGM. So how people could participate? Now, my lord, this is a problem not in personam. This is in rem. Even if I have not paid my taxes, even if I have not paid my dues, it is not that. You cannot hold an election by usurping the laws, and you in a pre-election process where AGM was not held, SGM was not held as per the competent authority, you declare the number of members on the 17th. And now, my lord, will kindly come to the impugned order in the petition, the Honorable High Court's order at page 110, my lord. Page 60 of the petition.
61.
61. My lord will kindly see hereby in this petition, I have not only challenged my suspension but also the election process. Therefore, my lord will kindly see paragraph 8. That is at page 61. In view of the above, the competent authority under West Bengal Apartment Ownership Act is directed to consider and dispose of complaints lodged by the petitioner and counter complaints lodged by the private parties in accordance with law after giving reasonable opportunity of hearing to all necessary parties the allegations that the election process has not been legally followed and the issue of suspension. Here I challenged both. Suspension of the petition shall be decided by the authority. The competent authority comes to a conclusion that the process of election has not been conducted properly, then necessary remedial measures shall be taken by the authority, including set aside the election. And since initially representation was only regarding suspension, I came in a hottest manner because 25th was, we received a notice, the 20th election will be held. So therefore, the Honorable Court give me an opportunity by paragraph 12. Learned counsel for the petitioner is directed to forward the competent authority all objections, representations filed by the authority at the time of communication of the order. So, my lord, we were given an opportunity. Now, lordship will kindly see when a particular election has been declared. Again, coming to the opposition, my lord, where I showed, my lord, the opposition where they have stated this. If my lord kindly allows me to again take my lord there.
Yes, page 7. Paragraph.
Page 7. Now, my lord, will kindly come to the annexure.
Yes.
P7. P7 is, my lords.
Yes.
My lord, will kindly come to P7, my lord.
P7 or 7?
R7. I'm, my lord, with this gizmo, I have some problems, my lord. I try doing it, but my opposition though. If my lord will kindly come to R7, my lord will find that this was declared. If my lord kindly comes to page 37 of their opposition. 37, my lord has got it?
Yes.
P7.
Yes.
These are the 31 candidates.
Opposition P7?
Yes. Opposition P7.
Page 34.
37. Annexure R7, lord.
R7.
I apologize.
Page 34.
37, my lord. 34. I apologize.
34.
I stand corrected. My lord, this is what they have referred in page 7. So, lordship will kindly see on 14/7/2025.
Yes.
They have already declared. And in their reply, in their exception, the notice which they are showing, which has been circulated, according to their best case, on 25th June 2025, declaring the election, was on, if my lord kindly takes up page 7, annexure B of their exception.
Yes.
Date and time of election, 20th July 2025. Vis-a-vis R734, candidates declared on 14/7. So, lordship, pre-election process, faulty. Taking advantage of that pre-election faulty process, you declare the number of candidates because 48 people also could not participate there. So, lordship, if
I not understand. Yes.
My lord,
14 July.
my lord will kindly just 1 minute, my lord, my exuberance. First, my lord will take P7 of their exception.
Correct.
Here, my lord, will this
14 July, they have declared 31 candidates.
My lord, this is first 25th of June.
Correct.
That is B. They are championing that all the pre-election process was followed and everybody was given notice. Now, by 25th of June 2025, they declare that AGM date and time is 20th July.
Yes.
So the election was supposed to take place on 20th July. Now, my lord, will come to their R7. On 14th of July 2025, they have already selected candidates. So no AGM was held, no election was held on 20th, or could not have held on 20th. And I came to this honorable court on 18th of July. The decision was 18th of July. So 18th of July, they ought to have come before this honorable court and said that there is no question of any election because already candidates have been declared elected.
Yes.
They did not do that.
Yes.
That whole process before the authority is an eyewash.
Okay.
So, and Lordship, one more point. What had fallen, they are championing only for one cause. I am owner of 2 flats. I am saying that I went, they said I'm not going to participate. I'm not going to dispute a question of fact. Not even one document comes which shows that pre-election process was proper. Now, because that pre-election process was not proper, you selected already R7. So therefore, on 20th, there was no election.
So what are the total members?
48.
Yes.
Now you selected 31.
Yes.
Of your own people.
Yes.
And on the 18th, that is at page 61, if my lord kindly comes to the main order of this honorable court, my lord will recapitulate. There, in the 4 corners of that order, they never said that they have already declared. Had they come and said,
that is not there.
Then my lord Justice Amrita Sinha would not have passed an order. So therefore, in my respectful submission, at the very outset, a person who comes to this honorable court, and now when I come with the second round of writ petition, you come up and say that no, everything was done. It was declared on the 14th.
Kindly take swing the time, Lordship's last order 6
My lord, we have already filed our notes of submission.
Today is not the date for making submission. And
I know clarification I was given.
Then I must have this opportunity to.
But it forms part of the my lord's record.
No.
That is their document.
Because
it is their document. You cannot play truant.
After having been acquainted with this submission, it means that there are no facts of interpretation.
My lord, my learned senior friend ousted me from the matter, just taking time.
No, my lord. He has today is the date, my lord, for only, my lord, for written notes of submitted.
Submitted
My lord, yes, my lord. Today, my lord, he has expanded the horizon of the writ petition. So, my lord, if your lordship kindly gives me an opportunity any day, my lord, I will deal with his submission. Today is SIR matters, and my learned senior friend is the source of all this.
Both the parties have filed written notes of argument, but the counsel for the petition argued the matter for some time. Accordingly, the respondents press for time to give reply. According to the adjourned, let the matter appear on 3rd September.
I'm grateful, Miller.
3rd September, come 3rd September, what is your reply?
Yes, 3rd September. My is over, Miller, because today my junior was not there.
Okay.
So I had, because I started this
3rd
matter all
September
that time.
within 10 matters for you.
Bring it to a logical.
Okay, no problem. Thank you.
Afternoon, 28.
Page number 28.
Yes, disposed of.
May I hand over the list? Appeal is on page number 32.
Disposed of.
Appeal is on page number 41.
Disposed of.
No appeal under adjudication. Liberty be granted to the petitioner to.
On the last occasion, they have stated that they are doing the process to release these 5,000 more under adjudication candidates, my lord. Because the submission from the election commission was that the digital signature was not put by the judicial officer. That is why they are showing as under adjudication. Now, if we are directed to file form 6 at this age, my lord, since
That's an appeal before the DEO to conclude the adjudication process. Similar orders have been passed in other matters as well.
then, my lord, I shall beseech your lordship to frame a timeline also, my lord, because
where is your
There's no appeal.
no appeal, my lord. The individual is still under adjudication.
still under adjudication?
Yes, yes.
Non-counsel
49 is the document.
Learned counsel for the petitioner submits that the case of the petitioner is still under adjudication, and as such, no appeal is filed. In view of the above, the petitioner is given liberty to make appropriate application before the district election officer for consideration of the case of petitioner for including the name of the petitioner in the voter list, if any, within a week from date, if any representation is made by the petitioner before the district election commission, the district election commission shall consider and dispose of the application within a period of 4 weeks after receipt of the application.
I'm grateful.
4 weeks on receipt of the application, if any, filed by the petitioner. Disposed of. Next. Disposed of. Disposed of. Disposed of.
One intelligence, my lord. In the cost title, there was name is Chandi Khatu. The name in the file is Chatni Khatu. CHADN.
CH Chandni. Chandni.
Leave may be granted to correct the cost title.
No, he is telling that only in the cause list.
Cause list
It is.
Cost list is a Chandi.
What is the good name?
Real name is CHADNI.
It is in the writ petition.
Yes, in the writ.
Chandni ka to. Yes, next.
166 is identical to 162 under adjudication.
Next.
Page number 90.
Disposed of. Give the name.
168, page number 11.
Disposed of.
Page 22.
Disposed of.
Murshidabad, sorry. In 170, my lord, I appear for respondent number 5, 6, and 8.
Now for the petitioner, page 110.
Disposed of.
171. Page number is 90, my lord. Only
Disposed of.
one correction is required, my lord. The petitioner name is Haji Kul and it become, my lord, Haji Ul. One K is, my lord, missing from
Instead of Kul, Kur, R. It instead of
HAZIKUL, my lord, only K is missing in the cost title.
K is there.
Petitioner, yes, in the petition, my lord,
In the
cost-
petition.
Yes, your lordship.
In which you want to correction?
The petition. Petition ভুল আছে
Article to.
HAZIKUL.
Yes, HAJIKUL. Ajikul.
मतलब आप pilot tendering में रख लो.
Next. हो ही गया. Dispose of. 173. None appears. No recommendation dismissed. 174. Falk. Disposed of. Disposed of. Disposed of.
177, I'm for the petitioner, whether to page number 30.
Disposed of.
Page number 29 was.
Disposed of.
I'm 79, page number 26.
179, I'm for the state law.
Disposed of.
Page
Dada,
number 20.
Dada.
180 is.
No appeal.
180. No appeal. 180, there is no appeal.
Service.
Where is the appeal? Individual service पहले था.
Liberty may be granted to file.
Can you then liberty may
What? Huh?
Page number 49.
Same order. Same as earlier, no? Once disposed of. Next. 181. Disposed of. 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 Ah. Why? Record करो. 191. Counsel for the petition submit that the petitioner is working in the merchant navy, due to which the petitioner has to travel abroad on duty, but due to the deletion of the name of the petitioner from the voter list, the petitioner is not getting the passport is are having, then क्या बोला? Due to the deletion of the name of the petitioner from the voter list, the authorities are not conducting the verification, for which the petitioner is facing difficulties. He submitted the petition already prepared an appeal before the appellate tribunal, being agreed with the deletion of the name of the petitioner from the voter list, and appealed for expeditious disposal of the appeal by the appellate tribunal. In view of the submission made by the counsel for the petitioner, the appellate tribunal is requested to dispose of the appeal as early as possible, preferably within a period of 4 weeks from the date of receipt of the order. Yes, next. Disposed of. Non-prosecution. Why? Petition name is already been included in the retribution, become infectious, according dismissed. Yes, then same order. Disposed of. Withdraw, same order. Included, name included. Yes, next. Disposed of. Disposed of. Disposed of. Disposed of. Withdrawal. Withdrawal, huh? Dismiss as withdrawn. Yes, no, dismiss, become infectious. Yes. How many petitions are there? There are altogether 7 petitions to file the present date application having different cause of action. Accordingly, writ petition is dismissed. However, dismissal of the writ petition will not prevent the petition to file their separate application. Yes, next. Next. Cause of. Again, others. How many? Others, how many petitions are there? Disposed of. Have you paid the court fee? Pay the court fee. Your course, otherwise you will not sign. Disposed of. Disposed of. Disposed of. Disposed of. Disposed of. None appears. No accommodation dismissed. Next. Disposed of. Others. All family members. How? How many family members? Disposed of. Paid court fee. Disposed of. Disposed of. I have disposed of all writ applications. There are three directions. The director of census operation and the charge officer, if they intending to take the service of the petitioners who are working as a teacher, they shall specify the date, time and place of census work to be executed by the petitioner to the head of the institution of the petitioners, and if any request is received by the head of the institution, the head of the school shall make necessary arrangement to allow the petitioners to go to for the census work and to make necessary alternative arrangement with the available teachers in their respective schools so that the education of the students shall not be affected. If the teachers are deputed for the census duty, they shall be treated as on duty in terms of the section 15A of the Census Act. If the census authorities or school authority depute any teachers for the census work, no teacher shall deny to perform their census work as assigned to them. আমি correction করে দেবে একবার পড় के फिर शाम को you will get the order in the unit. I will check again one new. All have been disposed of in a single order. হ্যাঁ চেম্বারে পাঠা দিই একটা আমি দেখবো দেন $22. Here for the petitioner. Who is partner? Nobody. Record on. Affidavit of service filed by the petitioner be kept with the record. In spite of service of notice, none appears on behalf of the respondent. The grievance of the petitioner is that the petitioner has made representations to the respondent number 1, but in spite of receipt of the representations as well as the legal notice of the petitioner, the respondent number 1 has not considered the request made by the petitioner. Counsel for the petitioner submit that press for an order directing the respondent number 1 to consider the representation submitted by the petitioner dated 19 September 2025. क्या बोला? The petitioner, and after giving an opportunity of hearing to the petitioner, dispose of the same. I am disposing of now on the respondent number 1 considered, and after giving an opportunity to dispose of the complaint. The writ court, what the writ court will do? What is your objection? Okay, you raise all the things raised before. I am not deciding anything. In accord. After hearing the hearing the petitioner, giving an opportunity of hearing to the petitioner and the affected parties of personal hearing to dispose of the same. Considering the above, considering the submission made by the counsel for the petition, this court find that the representation pending by the petition is pending. The representation submitted by the petition is pending before the respondent authority, and accordingly, respondent number 1 is directed Two, consider the representation submitted by the petitioner after giving the notice to the petitioner as well as the affected persons, and after giving personal hearing to the parties to dispose of the same by passing a reasoned and speaking order within a period of 6 weeks after receipt of this order. It is made clear that this court has not gone into the merit of the matter. The respondent number 1 shall decide all the points raised by the petitioner in the representation. Next. Yes. What is the matter? Medical negligence. Yes. Which hospital? Bellevue. You are appearing for the state? Yes. Who has given the written instruction? Petitioner has filed affidavit of service. Let the same be kept in the record. So and so appearing for the all to the respondent, appearing on behalf of the respondents. Counsel for the petition prays for time according cases adjourned. Let the matter appear on 9th September. Next. Yes. Who is for the authority? United Commercial Bank.
I was under the wrong impression that not require registration. After they could have waited for mutation, but I could not mutate properly my name. Bringing it back that registration has not been done. Now there is two aspects. First, there is provision of section 85 of the Registration Act that is just to worship. That has been complied by the Act. Supplied by power.
Yes.
Every revenue officer granting a certificate of sale to the purchaser of immovable property sold by public auction shall send a copy of the certificate to the registering officer within local limits of good the whole of any part of the comprise in the certificate. And such officers have filed the copy one. Already that is done. Then it is true that when the registration is done. But when I have made representation to the bank and they say nothing about it.
Nothing?
Nothing about it. Whether this has been complained or not.
So you have not been given the sale certificate.
I have been given the sale certificate.
So you could have been informed to the authority. Why? Every revenue, yes. Hmm.
Every revenue
Ah. Correct. That's correct.
They have to say.
That's correct. That's correct. So now what has happened? Who is for the authority? Now who is the authority? Nobody is appearing. 11:25. You serve them after. Now there is a change. November 25 years. I am fixing a date. You serve inform the note only date. The petition has filed affidavit of service. Let the same be kept with the record, but this court find that the service has been affected in the month of November 2025. But subsequently, in the month of April 2026, there is a change in panel of the government advocates. Accordingly, the petition is directed to inform the next date of hearing to the all respondents and file a press affidavit of service. This is the matter on 10th September. If I book there, don't. No, nothing. Only inform the date. Next. Yes. By the committee. In-house committee. So you have attended the inquiry, but no copy is served. So how the inquiry is completed? So you could not get the chance to cross-examine.
Even the inquiry proceedings, like I need and the proceeding papers, so that I can go and find. That also has not been given. And finally, the base of work, what is the procedure of service under which you and it's the that said one of the copies under one to the rest of the period of 7 working days. The person not given. Out of one given, one field did not be. For the entire proceedings papers will notify short form and provide representations are there. They are not provided with that. And finally, and orders which were given after the
Where is the first notice of complaint? Complaint copy not served to you. Yes. That's the inquiry report, not the complaint. So that's why when the complaint was made and when the first notice you received. Yes.
With utmost regards to reference to response to the later other matters hearing above, I would like to inform you that I due to inquire hearing on 4th of April, I have received a lot of requests later on 1st of April, but a copy of the submitted against the in that complaint, it was not on the the rights to submit then on the close of I request by the copy of the subject to internal committee. I was assured that I would provide against me ICCLG 512 informed as a respondent I submitted against me ICCLG as a respondent I am also inform me please and if I respond then I only request you to again provide the copy. I will also kindly also take the last notification 16th of June 2020. The date
Page? Yes. No, as per this letter, the inquiry process completed and inquiry report was submitted to you. Yes. Hmm. 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 Yes. When the first notice was issued to you? That is 2024.
Yes. Of March 2023.
Inquiry come.
Representation. First time that they have not provided from the subsequently but other documents they have not given in the inquiry report.
But come to the page 37.
Yes.
That is 28/8/2024. Here, representation received from so and so so and so. Where is the petition or complaint so and received so and so? Acha, National Commission of Scheduled Caste. Not by the. Yes, who is appearing? Page? Page? Baba, this is with regard to the Commission for Scheduled Caste. Where is the internal committee report with regard to the complaint? Sir, please, please. His case is that one lady made a complaint. On the basis of complaint, the internal committee was constituted. Committee has started investigation, inquiry. He has received the notice. He made the request to the committee, please provide the complaint. Complaint was not provided. Subsequently, evidence started, evidence recorded. He has asked for the copy of the evidence, not given. The authorities have taken the stand that inquiry report has already been submitted. So there is no provision for submitting other documents. So go by the inquiry report. So his contention is that once you initiated the proceeding on the basis of a written complaint, so first of all, the alleged charge officer is entitled to get the complaint. He is entitled to get the evidence recorded by the committee. He is entitled to get all the things. So where is this? What you are referring? That is with regard to the Scheduled Caste Commission, National Commission for Scheduled Caste. Correct. That he came before this court. His representation was not considered by the Commission of the Scheduled Caste. So this court has disposed of the matter on the basis of this. The hearing was conducted and it is found that he has not produced any certificate with regard to his coming under the scheduled caste. So that was he is not he has not challenged this order. His contention is that because if you have initiated the case, there will be a complaint. Kindly come to last page. Page 63. Page 63. Page 63 of writ petition. Got it? Go through. As per above reference, the inquiry report of ICC was already sent to you from this office bearing so and so. As the inquiry process is completed and the case stands closed, it is directed to clarify the clause on which you allowed to lawfully entitled to get confidential information statement submitted by it. So statement is against him. If suppose a criminal case initiated against B, correct? A has made a complaint. Police has registered a case against B. Case went to the investigation completed, charge sheet file went to the court. And police has submitted the final report. No case is made out. Okay, the accused will be acquitted or discharged. There is no cases. Whether the accused is not entitled to get the copies he is asking for. What? How? See, you are the advocate. Maybe instruction. That's I'm telling. You are the lawyer. If a case has been initiated against the petitioner and witnesses have been examined, statement recorded, he is not entitled to get the statement. How it is confidential? He is not a third party. Okay, third party is asking the statement. We can appreciate. Yes, third party is not entitled. He has no interest. He is a stranger. If suppose, what is I am telling you, one person made a complaint. Subsequently, three charge. One charge he accepted, two charge finished. He intend to go for the malicious prosecution. What document is required for the malicious prosecution? Which order? Which order? Sir, that commission order is not connected here. Here the case, please appreciate. Here the only case of the petitioner, a complaint has been initiated against the petitioner and the internal committee was constituted. Internal committee has proceeded with the matter. Petitioner since beginning asking for the complaint, they are not giving. Subsequently, you have completed the inquiry. Inquiry report was submitted. Is admitting that yes, inquiry report he has received. But after the inquiry report, what is the procedure? Final order? And how your authority is telling that the statement recorded during the inquiry is the confidential and the petitioner is not entitled to get that? The petitioner has filed the present date application praying for a direction upon the respondent authorities to supply the copy of the complaint and the statement of the witnesses during recorded during the inquiry by the internal committee. It is the case of the petitioner that the colleague of the petitioner has made a complaint against the petitioner, and accordingly internal committee was constituted. The committee has issued the notice to the petitioner to appear before the committee. The petitioner has appeared before the committee and has requested the committee for supply of the complaint on the basis of which the committee was constituted and inquiry is initiated. In spite of the request made by the petitioner, the copy of the complaint has not been served, but the committee has continued with the proceedings and recorded the statement of the witnesses. And inquiry report has been is forwarded to the petitioner. The petitioner has again made a complaint to the committee for supply of the complaint as well as the statement of the witnesses during the inquiry. In spite of, on receipt of the said report, on receipt of the request of the petitioner, the respondents have informed the petitioner that inquiry process is completed and the case stand closed, it is directed to clarify that the clause/rule which allows you to be lawfully entitled to get such confidential information or statements submitted before the ICC on 4/4/2024. Full stop. Learned Counsel appearing for the state railway authorities or respondent authorities submit that the petitioner has no right to ask for the complaint and the state. What about the complaint then? Given. Show me the receipt. Yes. What affidavit you file? He is asking only the complaint and the statement of the witnesses. If it is your case that all the things have been supplied, you give the report. But your page 67 is something else. Kindly come to the page 67. What the page 67 or 61? 63. Kindly come to the page 63. Your officer is of the view that the statement recorded by the ICC is a confidential document that cannot be supplied. Whether that is the law. Or shall I call this person? You file report. I am giving an opportunity. File a report. Get it then. Learned Counsel for the respondent authorities press for time to file report to satisfy this court that the copy of the complaint, the proceedings, and the statement has been supplied to the petitioner. Let the report be filed before this court on or before. No, complaint also. That's why you show the report disclosing the evidence that you have supplied the copy of the complaint, copy of the statement of the witnesses. File the report disclosing that the copy of the complaint and the copy of the statement of the witness have been supplied to the petitioner. Let the report be filed by 3rd of September 2026. List the matter on 7th of September 2026 within 10 matters. Next. No. Sorry. No. Yes, call the next. You are appearing for whom? Respond number 5 is West Bengal Yoga Neuropathy. West Bengal Council for Yoga, yes. Which council? Yoga. That's why they're telling they are appearing. Yes, they are appearing. And what about the 1 to 5, 1 to 4? 1 to 4. Who is appearing for the Director General Ayush? That is also state. Joint Secretary Ayush also state. Director Ayurveda is also state. Then Central Bureau of Investigation, who is appearing for the CBI? And what about the other private respondents? Ah, 11 you are appearing. What about the other? Where is the affidavit? Have you filed the affidavit? Yeah, delivered. Nobody is appearing. So affidavit completed. Filed by the separate report by way of an affidavit prepared and filed by the state and the council by 21st of November. Nobody has filed. Yes. Yes. Next, your report is ready. You have to change that. No, yeah, they're filing the council for the state and the council for the and the council for the respondent number 7. Respondent number 5. Praise for extension of time to file report by way of an affidavit. Let the report by way of an affidavit be filed within 2 weeks after supplying the copy, after serving the copy to the land council for the petitioner. The petitioner has liberty to file. Maybe they may change or whatever. The petitioner may be liberty to take exception to the said report within a period of 1 week thereafter. List the matter on 2 week bola na 1 week. This is the matter on 23rd September. Okay, at the time hearing, we'll see to that. Yes, same. Yes, next.
My lord, in item number 29, my lord.
Yes.
My lord, in item number 29, my lord, before my learned senior friend starts, my lord, this matter is related to, my lord, another matter, my lord. My lord, both matters may be tagged along, my lord, because similar facts, my lord. My lord, my matter is monthly list number, item number 212, my lord.
Okay,
that matter was meant.
Let me hear this first. Yes.
My lord.
None appears on the state. The petition director informed the next date of hearing to the London government pleader and to file for. Yes. Yes, who is appearing for the state? Now, no, that was a different government. 2 weeks.
My lord,
Land Council appearing for the you are appearing for? Instead, what about the Union of India? Now, again, you will then you take. I remember now. You have created the problem. Now, what he will say, you will adopt. Land Council for the Land Council appearing for the state press for extension of time to file report. Time to file report. Let the report be filed within report by way of an affidavit be filed within 2 weeks after serving the copy to the Land Council for the petitioner. The petitioner is at liberty to take exception to the report if any within a week thereafter.
my lord, may my matter be also tagged with this matter? My lord, similar set of facts, my lord, monthly list item number.
List the matter on 22nd September 2026. Full stop. Yes, which matter?
My lord, item number, monthly list item number 212, my lord. Appearing under urgent motion.
Item number जो भी under Land Council appearing for the petition in WPA number देख लेना. Submit that these are also an analogous matter in prayed for fixing the said writ application along with WPA number 25458 and 24548 of 2025. In view of WPA number.
My lord, if I may state the WPA number, my lord, WPA 25836 of 2025.
5836 be placed along with after WPA number 24548 of 2025. ठीक है?
I'm so grateful, my lord.
Affidavit of service, complete the record. Next. Assignment. Just a minute. आज और एक था ना, आपसे क्या करो, असाइन मैटर अलग से करो, स्पेशली असाइन मैटर करके जो भी है, क्योंकि ना कल को डिटर्मिनेशन चेंज होगा लेकिन वो फाइल मेरा सज जाएगा ना, तो फिर वो पड़े रहेगा. Yes, what is the submission? Correct. We are appearing for whom? Therefore, additional managing director, Uttar Pradesh State Road Transfer. And what about the 3? 1, 2, and 3 you are appearing? MSTC. And 2 and 3? 2 and 3 you are appearing? 1 and 3. What about the 2? You might be. 2 and 4 you might be. So he has given the odd number to you. Yes. What is the maintainability? Let me hear the maintainability. What the maintainability point? No cause of action. Second? What point? Page 31. 31. Para 17. Yes. Yes, what is your objection? Yeah, what is your objection? You are not a necessary party. Okay. Okay. That is, yes. What is the representation? Okay, your office is here, no problem. And the tender was e-tender, correct? But where your tender was accepted? Then when you where you deposited the money? Yes, satisfy which part cause of action? Satisfy this. Because Kusumingot you are relying upon, Kusumingot says a small cause of action will.
In as much in Iron said the e-auction process was administered by the respondent number one from its registered office at Kolkata, and the contractual relationship between the parties emanates from and is governed by the act and decisions of the respondent situated within the jurisdiction of the party. Has to be administered by the office of the respondent from within the jurisdiction. First, they might raise your lordship, I must asking your lordship. We will first concern your lordship that the supply is possibility. Even if I claim the COVID benefit, plus I cannot perhaps claim the monetary benefit. That is why I have not made that clear in the report. Under Superkumar argument, I can make that clear. That will come up. Your lordship, disputed question of time. So I cannot.
But you file this writ petition only asking for the reconsideration. Yes, yes, because the new cause of action arose.
Acknowledgement of liability. For liability, this which was supply of goods, not your with respect to payment of money. Because with respect to liability, I have not raised the period of limitation. But all with respect to limitation, my right is not extinguished. It does that I cannot impose that right. You are also answer. So the people balance. But there are parallel otherwise,
Where is the representation? Yes, so kindly come to 62. Yes. Hence, in the light of the above category, it is categorically demanded that to deliver, provide pending quality of the quantity of the materials in accordance with the auction catalog. The action catalog will come under the purview of the terms and conditions of the tender. In terms and conditions of the tender, it will come under that. Then the clause 17 will come into play. Okay, if they are not making, they are not coming, they are not giving the answer to you. You have a two author. You have a section 11. Then no, you have a section 11.
Therefore, those statements are not getting any answer from our side, from them. Whatever issue,
Yes, anything. So what do you want? No, the representation is not a simplicity. The representation is the anticipation. Take instruction whether you want to continue or you take further steps to other code. Take instruction. The counsel for the petitioner prays for adjournment for taking instruction. Actual cases adjourned. Let the matter appear on 11th query. Which one? Item number 125 of the monthly, though the matter is listed as 125 of the monthly list, but due to paucity of time, the matter could not be taken up hearing. Counsel for the petitioner prays for action. Submitted the interim order still today and paid for extension of interim order. In view of the submission made by the counsel for the petitioner, interim order is extended till 29 September 2026 or until further order, whichever is earlier, let the matter remain in the list. Yes, close. 30. Come tomorrow. Yes.
He did not file affidavit. If your lordship kindly take the para 42, my lord.
Yes. Yes.
My lord, in only, my lord, as abundant precaution so that the respondent do not waste further time in filing the affidavit, my lord. Your lordship had directed 3 weeks, my lord. May I pray, my lord, if any day next week, my lord, it appears as to be mentioned, my lord, for necessary and appropriate orders to be passed in the meantime.
My lord, I beg to appear for the
It is already
respondent.
appearing as 1.
My lord has directed us to file our affidavit, my lord, due to the pendency of the appeal, as my learned senior friend has said, we could not. My
You are
lord,
appearing for room hall.
respondent number 1 to 3, my lord, for the honorable speaker, my lord. I'm just begging before your lordship to grant me 3 weeks time so that I can come back with my affidavit and let them file a reply to that within a week and kindly fix the matter after 4 weeks. The interim order is for till 2 weeks, as per the division bench order, my lord. My lord, orders has been upheld by the honorable division.
To be mentioned as once.
Yes.
And then the orders.
काज करो ये जो 145 है ना
135
उसको Monday to be mentioned में कर दो. Come on that day, then I pass it.
I shall pray the same thing on Monday only.
Come on.
Same, yes. Otherwise, the order has to be passed on. But may I come back with the order on that day? 134.
To be mentioned में कर.
Grateful lordship.
May I be permitted one matter, item number 37. Yeah, it is the matter about 5 matter,
Item number?
37.
Ah,
It is fixed for hearing. Another matter, another benches taking this matter for this irrespective of classes.
what you want?
Kindly Lordship release this matter.
Record an order. At item number 37. Learned counsel for the petition submit that this court is not having the determination to decide the issue raised in the present writ application and prays for release of the instant application. In view of the submission made by the counsel for the petitioner, WPO 233 of 2024 is released from the list of this court with the liberty to the parties to mention before the appropriate having determination. Released, note kori de. Next. Yeah, yes, yes. अच्छा, ये delete करो. ये रहेगा. The matter is listed as to be mentioned for correction of the order passed by this court dated 24th of July 2024. It is found that this court has passed the order on 24th of July 2026 in IAGA Com 1 of 2024, in CS Com 817 of 2024 within bracket Rahi Infotech Limited versus Union of India and another, but inadvertently in the cost title of the order dated 24th of July 2026, the case number is recorded as CSOS 8 of 2025, IA number GA2, IA number GA2 of 2025 within bracket Jayashree Wadhwa versus VB Seva Trust and others. Considering the above, considering both the orders, this could find that inadvertently the order passed in GA Com 1 of 2024 in CS Com 817 of 2024 dated 24th of July 2024 is recorded in CSOS 8 of 2025, IA number GA2 of 2025. Accordingly, the order recorded in IAGA number CSOS 8 of 2025, IAGA number 2 of 2025 dated 24th of July 2026 is recalled. Yes.
It's declaration of fraud account of the bank. Lordship has heard me. When Milord, the show cause notice was issued. When the show cause notice was issued. Then Milord, the circular, earlier circular of master circular was in operation. Now, when the order has been passed, Lordship will remember, Lordship has extensive notice. The new circular has come into effect. Now, Milord,
July 24.
Yes, July
15 July 24.
Remembers, Milord. That Milord explicitly provides Milord or Milord compliance of natural justice Milord. If your Lordship have given a copy of the circular, that is perhaps with your Lordship's speech Milord. Milord, if your Lordship takes Milord the RBI fraud Milord management circular, if your Lordship takes 15 July 2024, Lordship has a copy.
Yes.
It has come Milord. Recommended that it will be perhaps on the 1st July 2016. Now, Lordship will straight away come to two things, Millard. Millard, kindly have a look at 2.1.3. That will be page number 4.
2.1.3, yes.
Or Millard, prior to that, kindly have a 2.1.4. This is now under Millard the statute, it's under the Millard guideline itself. A reasoned order shall be served on the person entities conveying the decisions of the bank, declaration and classification of the account as fraud as otherwise. The order must contain relevant facts, circumstances relied upon, the submission made against show cause notice and the reasons for classification. So, Millard, this is how the order has to be put up. It's 2.1.1.4. Now, Millard, kindly take 2.1.3. Millard, the bank shall constitute a committee of board to be known as Special Committee of the Board of Monitoring and Follow-up of the case of fraud, with a minimum 3 members of the board consisting one of a whole-time director, a minimum 2 independent directors, 2 non-executive directors. The committee shall be headed by one of the independent directors, non-executive. So order must Millard spell out Millard who were they and they were there or not. Now Lordship will straight away now take Millard the relevant portion, if your Lordship takes Millard, 4.1.4, which is at page number 8.
Page number?
8. 8 is at the bottom.
Yes.
4.1.4, the bank in case of sole lending or individual bank in case of multiple bank arrangement of consortium lending shall ensure that the principles of natural justice are strictly adhered to before classifying or declaring an account as fraud. So, Millard, that is Millard, the Supreme Court judgment.
That is Rahul Agrawal.
Yes, Millard. That is Millard. Rajesh Agarwal is quoted in the bottom. Now, Millard, kindly take Millard. What are the consequences? Because Millard, it will be obviously argued. This Millard, I Millard, think Millard is going to argue that writ against a private bank is not maintainable, but it has penal consequences. It carries away my right to carry on further business. Because if I don't get fund, I do not carry. It's my legal right to carry a business. Millard, 4.4 penal measure, page number 10. 4.4.1, the person entities classified and reported as fraud by the bank and also entities and person associated with such entities. So not only Millard classified but with association also shall be debarred from raising funds or seeking additional credit facilities from financial entities regulated by RBI for a period of 5 years from the date of repayment of the defrauded amount, settlement amount agreed upon in case of a compromise settlement. Lending to such person entities being commercial decision, the lending bank shall have the sole discretion to entertain or decline such requests for credit after expiry of the mandatory period as such mentioned in paragraph 4.1.4.1. So, Millard, absolute bar Millard for the period specified for 5 years thereafter, even after that cooling period, it's a discretion on the bank. Millard, offense Millard, my right to carry on business has to be but and it is flowing from the master circular issued by Reserve Bank of India under the Act. So maintainability not an issue. Millard, because Lordship last judgment I had read Millard against the private bank. So Upal Bose and Mr. Joy before I think my learned friend has also read it. Now Millard, kindly have a look at the show cause notice one and I show judgment. Kindly have a look at page number 80. The show cause. Millard, it's dated show cause notice. It's Millard, page number 81. If your Lordship takes Millard, what is the show cause notice? Millard, the facilities are cash credit and term loan. It's 1st July 2024. Millard, it's Millard. It's Millard 1st July 2024 between Millard.
Yes, 1st July.
Yes, that's Millard an admitted position and the circular is Millard came into effect, which I just know reserve the master circular, the present master circular 15 July 2024. So show cause notice is as per the old, but order is passed as per the when it was in operation. Millard, kindly take there are advances from one division to the other division and there has been given advances by manufacturing to the EPC division. That's Millard engineering project procurement contract division. The company has 2 divisions. One is engineering procurement contract and is division and other is the auto division and auto division. And the same are classified under the long-term investment under the AFS, that's annual financial statement of 2019-2020 the annual financial statement can be further classified and the other current assets under such and such. Such and such. Similarly, the advances received from the manufacturing division classified as EPC and auto division under the head share capital of APS such and further reclassified and the other currently reveals that there has been utilization of borrowed funds from one division to other division. Now, the company is one. There are two divisions, auto division and Miller, the EPC division. Now, Miller, kindly Miller takes Miller, next Miller. The balance of trade payables such and such of AFS as on increased to 93 lakhs as on such and such. However, detailed addressee of the GST number for the reasons of outstanding. Now, value of stocks as per AFS lakhs, whereas the during physical verification of stock of such and such, the premises was found shut and no vehicle observed from outside the showroom. Now, no copy of the FSA or the addendum was forwarded to the petitioner by this way. But I have got it because I got it. That's what constitutes. Now, will kindly take the next page. Page 82. Moreover, Bank of Baroda and Axis Bank, major lenders for manufacturing division under the consortium, has declared an account as fraud and report to RBI through PRILC platform. Hence, RBI guideline, we have decided to classify you as fraud and to report to RBI. Lord, barely because Lord, Bank of Baroda and Axis Bank has taken, is it automatic that they will do it with us? So that is their case. Now kindly have a look at the reply to the Shukla.
You are the borrower?
I am the Miller.
You are the director?
I am the director
of the borrower.
Miller, so connected to the borrower. As Lordship has seen penal version, connected to the borrower. Let's Miller case. Circular in this Miller jurisdiction, I have to proceed on such case. Now Miller kindly have page 86, which is 19/7/2022. You are aware from the nature of the activities of the company with successive loans granted from time to time, you never raised any red flag with the financial records of the company. Auditors have now red flagged any issue that will facilitate fraudulent activities of the company. As such, the show cause notice is nothing but an act of non-application of fine, arbitrary, etc. etc. Now, Miller, first, which he says, which I goes to the root of the matter, there Miller Divan says Miller. Miller, kindly Miller, have a look at serial number 1 at 87. Miller, paragraph number 1, if your Lordship sees Miller, there is basically Miller utilization of fund given to the auto division to the other division.
You're the same Rajesh Agrawal?
Yes, yes.
Earlier case?
Yes, yes. That was PNB. That was PNB. Someone else had been. I have. Miller, kindly take Miller current asset. Miller, it has been division to auto division, but it has been given. Miller, it has been Miller utilized for some other division. Now, Miller, kindly have a look at Miller, the answer. Miller, the answer is most, first and foremost, any review and comment on the financial transaction of EPD division or outside the purview of your bank, and therefore we shall refrain from giving answer to reply the question or comments of Miller, no loan. It should have been a case Miller, he has Miller given a loan Miller to Miller the EPC division. He has Miller himself Miller not given a loan to the EPC. The case is Miller loan given to the EPC division is used in the auto division. I am a bank.
No, so
I show the audited report file.
correct. The amount which the amount which you borrowed for what purpose?
For different banks. For this bank itself, I am only on this bank. Miller, it's a this bank because the order is by this bank. Miller, it has been given Miller to the auto division.
It's in the forensic audit report.
The case is what? The case is Miller loan given by two other banks in the EPC division has been utilized in the auto division.
Okay.
But so far as this particular bank is concerned,
his amount has not gone out.
he has never Miller given loan for the EPC division.
That's why, as per your case, might be it has been, but he is.
By some other else. That Miller, I have other points on the Miller, their Miller audit report. But so far as this bank is concerned, this is Miller further fortified by the affidavit.
Which bank is?
Miller, this is Miller Tamil Nadu, Miller
Mercantile Bank.
Mercantile Bank. They have given in the auto division. The allegation is Miller, the loan of Miller given to EPC division by PNB and Axis Bank has been Miller utilized Miller is the auto division. But so far as this bank is concerned, Tamil Nadu Mercantile Bank, their loan has been given on to the auto division only, and that is fortified by the reports.
Yes.
Now, page 89, admittedly, this forensic audit has not been submitted by them. So this is, they have to do it. Some other bank does, it is not their concern. If you have taken an independent mechanism, to declare me as a fraud or the account is a fraudulent account, pursuant to your order passed by you. And kindly take page 90, serial number 32. Since Axis Bank and BOB has taken, so I have also taken. So now kindly have a look at the order. This is at page number 30. One forwarded by a communication of 26th of November 2024.
Page?
So, page number 31.
Of the writ petition?
Of the writ petition. Everything is the writ petition and two documents from its Miller 26/11/2024. This communicated. Kindly take 32 is the result order. So we have to go by this. An order is an order, it cannot be improved by affidavit, supplementary affidavit, or some other document here. This is what has been given to me. I will challenge this in court. Kindly take the order. First of all, the order is absolutely cryptic. If your lordship takes, and it has been signed by the branch head, page 34, not by the committee. Page 34, signed by the branch head. And look below what is stating in very cryptic. First paragraph, kindly takes the Supreme Company Limited was incorporated such and such, having 3 division, auto division, sole banking.
Where from you reading?
Page 30.
Yes.
Auto division, sole banking, manufacturing division, consortium. So sole banking is auto. That is this division. Why I say? Now manufacturing division is the consortium. And EPC division, multiple banking. So I fall within sole bank. This bank. So what has this writ petition in concern? Has been availed credit facility from Tamil Nadu Mercantile Bank, auto division alone at its Calcutta Bank 23/5/2015. So what has happened for transfer of funds from EPC division or the other division is not discussed. Because your amount is to the auto division, remains with the auto division. So this goes to the root of the matter. Now kindly take next, the forensic audit was carried out in conduct accounts mentioned by such and such. The conclusion of the forensic report dated 4/1/2024 point manifestation of fraud by the borrower on the account as follows. Now kindly take. It has been observed that there has been advances from one division to the other division. There has been advance given by the manufacturing division to EPC and auto division, as same are classified as a long-term investment in AFS number such and such and AFS number 2221 and reclassified as the other current assets in AFS 2021. Now paragraph 2, it is observed that the balance trade payable, that is reiteration of the show cause notice. Now para 4, the company has not furnished requisite information which has very much noticed and induced the scope of audit. The company has furnished the inability to provide information required by the accounting software. Labor unrest. Kindly take the next page. On the basis of the above facts and cooperation of the borrower, during their audit, forensic confirmed that siphoning of the fine by way of stocks and other fraudulent transaction by the borrower. Now this is not part of your show cause notice. Now kindly have a look. The bank has received the company's representation of Harish Kumar Agarwal and Prakash Kumar Agarwal. Under the circumstances, in view of the facts, it is concluded that the cause submitted by the company is not satisfactory. Further, it is deemed the director Prakash Kumar Mandla is classifying a fraudulent. Accordingly, revisiting the grounds on which the show cause notice dated such and such was issued, the bank determines the borrower account Mr. Supreme Company Director Harish Kumar Agarwal, Prakash Kumar Tiwari as fraud, and all attendant consequence, including classification reporting with intent. So this is the
yes.
Where is the consideration of the show? Reply to the show cause notice by me of the grounds which I have stated. Where is the consideration, Millard, of Millard page 82, Millard? This is not reason. Lordships have already held. This cannot be stated as reason. And the circular, Millard, 2.1.4, Millard, says how reasons has to be given. Where are, my lord, my consideration of my responses?
Yes.
First of all, there is no, my lord, why, if your loan is for the auto division and restricted to auto division, how can you, my lord, take up the issue, my lord, of some other bank where their funds have been given to EPC division, which, my lord, in other matters I'll contest. To auto division can be a factor here because your loan is restricted to auto division. And the case is everything has gone to the auto division. You have never invested or given loan in Millard EPC division or the other division. And this is 45 by Millard, their Millard, affidavit Millard, filed in court. An affidavit of Millard G. Rameswaran on 20th August 2025. Lordship, two things, Millard. Straight away, Lordship in kind.
Yes.
Kindly have a look at review committee. Kindly have a look at page 17, 1717, the report starts. If your Lordship will kindly have a look at page number 17. Willard, this is the effective summary. This was Willard not given to me. Kindly have a look at page number 21. 29. 29. Let's straight away come to 29. Kindly Willard takes Willard. What is Willard? PNB's Willard. This is the audit report. I go by the audit report. Kindly Willard takes Willard page 30. SKBM and company is the audit report. We have given the company who has given the audit report. Tamil Nadu Mercantile has sanctioned credit facility for auto division. On the basis of the information provided to us, the sanction is as follows. So they are not connected with the Willard EPC division, EPS division. Kindly Willard takes page 29. Bank of Baroda and Axis Bank are given Millard for manufacturing division. Canada Bank, Indian Bank and UBI has given for the project division. So far as Tamil Nadu Bank is concerned, only auto division. There is no allegation that the funds from auto division has got to the manufacturing division or EPS division. This is Millard their document. Page 71. Kindly now straight away come to page 71, Millard, and we have a look at page 71. Kindly look at the audit report. Check the audit report as it stands. That's what this matter is concerned. Page 71. There are two disclaimers. Clause number 5. If your Lordship takes me, Lord, just above scope of audit and terms of reference. Third one. Page 71.
Yes.
While utmost care has been taken in carrying out assignment comprehensively, we have not examined, interrogated any witness. As such, our findings do not have interrogation based. Conclusion are based on the methodology, logic, expert and extensive analysis available of data, facts and figures presented to us. Whether those wrongdoings were mainly on account of gross negligence or done with malafide intention cannot be identified by the forensic auditor. Detecting intention requires a thorough interrogation investigation techniques by competent authorities. Now, what is fraud, Millard, under section 17 and 16, read with section 17 and 16 of the contract? So it's clear. Now, Millard, to support Millard his order, he will not give someone something, Millard, that committee has recommended. Millard, I have not been served, at least, Millard, with this recommendation at page 86. He also relies upon the reasoned order at page 91, but Lordship will kindly take page 86. Lordship has seen who should be the review.
Yes.
The extract of resolution passed in the review committee to the board of willful defaulters and fraud meeting at such and such a statutory 2024. Now, Millard, the resolution has been given, Millard. Now, Millard, this is the resolution, not the order. And there's a resolution, no sign, who are present, not there,
No letterhead,
no letterhead.
nothing,
Because
not
I have
even
not
say,
been served with this. Was I served with this?
not even signature.
Not even signature. How do I know Millard, who Millard?
Just keep pen.
How do I know who is the committee? Who is present? How my show cause notice has been dealt with? Reply to show cause. Where is Millard? The sign of the Millard person. Lordship has to see who are the body, who are the person designated or who are the person involved in this committee. Who is the committee? He speaks of a review committee. Now this is unsigned. If Lordship passes an order, what is Lordship? Any Millard quasi judicial authority, even a direct, even Millard a DM passes an order, it should bear his signature. This was not given to me.
Not even letterhead.
I am Millard only favored with Millard the order of the branch head.
They have not disclosed the constitution of the committee.
It's where it's in
There's an
there
order.
has to be-
No, there is an order and they are not disclosed.
I'll kindly see next page, my lord.
Page 87.
88, 89,
Where are the names? Who is? Who are the three
my lord,
persons?
page 88, my lord.
Page 88. Yes.
Names are there. My lord, committees, the names are there, my lord.
Where?
My lord, the Sri Sales S. Nair, MD and CEO, Sri Vincent, MD and ED, Sri Niranjan Sankar,
Correct.
ND, SR.
This is the, but for the each and every cases you
My
have
lord,
to
next, this, for this purpose,
Yes.
my lord, kindly see 89, 13. My lord, these are the committees, my lord.
Yeah,
And
89.
89.
Where is that?
My lord, this committee, I am giving the resolution of review committee of board on willful defaulter. My lord, kindly comes to page number 88. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. My lord, 11 number. Last but one, my lord. There is RCWDF 88.
Page 88.
88.
RC.
WDF. Well, we have several committees. The members we have putting in one page, and there are committees, Malad, NRC, ACB, MC, so many committees. And these committees, the last but one, RCWDF, Malad, Review Committee of the Board of Willful Defaulters.
Correct.
Malad. Persons are Malad. Malad, kindly see, they are present in this person is, first of all, Mother Sri Sales, Sri Sali S. Nair, MD and CEO. Then Mother Sri Vincent, MD in ED. Then my lord SKB Burma 6, serial number 6. KB Rama Murthy, NED, non-executive director. Then my lord, 9. Sri S. Siddharan ID, individual director. Then my lord,
No, that's correct.
Sri
See,
R.
I am not on that. They are the persons who are working as RMC, SRMC, RCMC, whatever it may be. So for each and particular case, so how you can identify who are the, because you have to give the constitution of the committee. Where is that?
Well, resolution we have giving this committee.
This is the composition of the members and chairperson of the committee as on itna. Correct. So first is the Sri Shali as Naya. Shali as Naya, RMCs. What is the RMC?
RMC.
88 first. Saleh as
page.
Saleh as Nair, MD.
MD and CEO.
Correct. Then you can go directly. So third, he is not the NRC, not ACB, he is the RMC. RMC, then SRMC, SRCS, MC, then all these things. So how?
Last one of the RCWDF, this is the committee. The committee.
That's why I am coming one by one. So E is the RCDFW. So in all cases, C is the what is all the
All case except CSR and DC, the MD and ED was not the member. In all cases, he is the member, my lord. Kindly see, tick portion, my lord.
That's I'm telling. He is the then kindly come to the next one. Vincent MD. Correct.
He only 1, 2, 3, 4, 5, 6, 7, 8. 8 committee member. He is 8 committee member.
Correct. Then that's correct. So for this case of the petitioner, who was the chairman?
On that particular
This case.
particular case, my lord, that we are giving.
This is the overall. This is the overall. This is the composition of the members. Yes, he can be appointed because it has been notified. They will be. But each and every case, because bank is having 1,000 cases.
My lord, that is in the. I am giving the resolution, committee resolution, whereby the last part of the committee was also informed. The committee
which resolution?
This 86.
86.
86, my lord. This is the extract of the resolution passed by the review committee of the board of willful defaulters and frauds meeting held on Tutiguri on 30th 10/24.
Correct.
Well, this is the meeting resolution, and the committee. Well, kindly see, while deliberating the note, the committee was informed that the so and so committee. This committee formed by my lord this 6%, 1, 2, 3, 4, 5%.
Committee cannot be 5%.
My lord, kindly see. Kindly see.
Come to the
1,
master.
2,
Most importantly,
3, 4, 5.
Then you come to the master summon.
Your lordship did not go, my lord. Page 86.
My lord, that is not
31
applicable at all.
2024. Date. My lord, the order is dated, my lord.
What is the date of the resolution?
My lord, resolution is 31/10/2024.
How you can
30/10/2024.
How you can say?
Order is, my lord, 26/11/2024.
No, how? Acha 30/10/2020.
Yes, and my lord, composition of the committee as on page 88, 31st March 2025.
Yes, 31st as on 31st of March.
2025. And my lord, meeting, date of meeting is 21/8/2025, page 89, and 26/3/2025. How it can cover such a scenario?
My lord, they are giving the latest committee formation, this thing, my lord. On particular date, they are not giving. And apart from this thing, my lord, the
31st
circular.
March 2025, date of meeting is also there, page 89. Date of meeting is also there. He has given the right document. 21/8/2025. Lordship has found the date of meeting.
Yes.
28/1/2025.
Yes.
26/3/2025. So these are the persons which are relatable to these two meetings. And this is the review committee for that. My is a prior one. And there is no naming. Milord, if one signs an order or a recommendation, you have to sign it. Other is vitiated.
At least the position should be given. How the resolution? How you can treat this as a resolution? Where is the signature of the committee?
My lord, serial number is there, my lord. Those, my lord, kindly see the resolution page 86. There is a board resolution. They recorded in the board that they are typed it and they are giving it. And the minutes copy, my lord, RCW Q31 2024 and 25/10. Well, they're giving this thing in the office. Well, the 86.
86.
First one, serial number in board resolution on particular date. This resolution serial number is given.
Board resolution passed in review committee board number so and so hold on Tutikudi on 31st. So this is the board resolution. So where is the signature of the board member?
No, there is that will RCWD. The number and the number my learned friend says is RCWDF.
No, where is the number? Where is the number? Acha, this one. RCWQ31, yes.
RCWDQ31. And he is referring to a number at page 80.
Let him complete his submission, my lord. I satisfy, my lord. This read code does not have any right, my lord, to entertain this application. My lord, I have, my lord. Let him complete his submission.
RCW.
That is his submission. RCWDF. RCWDF. So how this is this? First of all, it's for the prior period.
Where?
Below 88, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Name of director RCWDF. Yes, referred to. On the top. Lordship has found from last. Just before DC, Miller 31st March 2025. Then there is some writing DC just before DC. RCWDF. Top portion. It's Miller.
RCWDF.
And Miller, C Miller, what is
RCWD.
RCW303. First of all, Miller, it is for the meeting as of 31st March 2025. For the meeting, which is the next day, this document. Date of meeting is 21, 1, 28, 1, 2025 and 26, 2025. And this is a prior resolution, prior date.
Then again the question arose, because if it is so, okay, if it is been accepted, if it is accepted, okay, as per you have made this. So how the notice has been sent by the manager?
That is, my lord, answer is there, my lord. The resolution itself, my lord, kindly see page 87. The third, the author is the branch head to send the rescind order to the borrower company and its directors.
Correct. That's why that resolution, where is the resolution signed by the party? You have a original resolution, or this is extract?
Then, my lord, I need to get instruction regarding that. Before that, my lord, one issue, my lord, whether this petition at all, my lord, entertainable. This writ petition is at all entertainable. I am not the state. I am the private limited company incorporated in 1911, my lord. I am doing only banking business, my lord. My lord knows the latest judgment, my lord. The A. Subba versus Mathu Finance and জানো তো ওটা দেবো
private loan amount.
Muthoot Finance. Kindly see the my findings, my lord. My lord, 9. My lord, 1, 2, 3. My lord, page serial number 9, my lord. We may sum up thus. For issuing writ against a legal entity, it would have to be an instrumentally or agency of a state, or should have been entrusted with such functions as are governmental or closely associated therewith, by being a public importance or being fundamental to the life of the people and hence governmental. 2. A writ petition under Article 226 of the Constitution of India may be maintainable against the state government, authority, a statutory body, an instrumentally or agency of the state, a company which is financially or owned by state, a private body run substantially on state funding, a private body discharging public duty or positive obligation of public nature, a person or a body under liability to discharge any function under any statute to compel it to perform such a statutory function. Then, although a non-banking financial company like the Muthoot Financial Limited, which are concerned, is duty bound to follow the abide by the guidelines provided by the Reserve Bank of India for smooth conduct of its affairs in carrying on its business, yet those are of regulatory measure to keep a check and provide guidelines and not participatory dominance or control over the affairs of the company. 4. A private company carrying on banking business as a scheduled bank. I am a scheduled bank, my lord. I have incorporated my 1921. I am a scheduled bank. In banking law, my lord, I am not the state, my lord. Then, my lord, a private company carrying on banking business as a scheduled bank cannot be termed as company carrying on any public function or public duty. Normally, the mandamus is issued to a public body or authority to compel it to perform some public duty cast upon it by some statute or statutory rule. In exceptional cases, a writ mandamus or a writ in the nature of mandamus may issue to a private body, but only there where a public body is cast upon such private body by a statute or statutory rule, and only to compel such body to perform its public duty. Merely because a statute or a rule having the force of a statute requires a company or some other body to do a particular thing, it does not possess the attribute of a statutory body. If a private body is discharging a public function and denial of any rights is in connection with the public duty imposed on such body, the public law remedy can be enforced. Duty cast upon the public body may be either statutory or otherwise, and the source of such power is immaterial, but nevertheless there must be a public law element in such action. Accordingly, their findings is there, last page, last page, serial number 12, the petitions are dismissed. However, if petitioner has any grievance to redress against the finance company, it shall be open for the petitioner to avail appropriate legal remedy before the appropriate forum in accordance with the law, including approaching the ombudsman of the RBI. So my respectful submission, my lord, I am not a state, my lord, under Article 12, my lord. I also raised, my lord, in my opposition also I am stating, my lord, that although this earlier judgment is stating, this is judgment of 2025. For that reason itself, my lord, this application is to be dismissed, my lord.
Yes.
And regarding that, my lord, issuance of, my lord, I issued the notice prior the date of notification, whether this notification is applicable to me, all those terms, condition, all those things is applicable to me or not, that is the question, my lord. I respectfully submission that is not applicable to me, this notification is not applicable to me, as because I have issued the notice on 30th July, my
Which
lord.
notification is not
My notice,
15 July.
so-called notice, my lord, 30th
15 July.
This notification is not applicable to me. At least this process, my lord. I already started the process on 30th, my lord. Well, before
which notification, under which notification you have processed the matter?
Well, earlier there is no specific RBI notification, my lord. There is this notification only.
Okay, under which notification?
RBI, my lord.
Which notification?
My lord, 2016 and 17 notification.
That's page 36 of the petition. I have placed that, my lord. I did not, my lord. Want to place it page 61, I have already placed.
And my lord,
36 at 60. I have already placed it. I did not place your lordship.
And my lord, they are giving the wrong impression before this court that we have not received notices. What happened, my lord? They are stating in their plain, my lord, their writ petition, when they have received the notices, and my lord's his own judgment, my order, my lord, judgment, my lord, passed whereby that is so ratified by my lord that they are accepted the notices. My lord pass the one judgment.
I have not a notice.
No. You are stating.
They have said, my lord, that is not the order which I am challenging.
What you have stated in the writ petition. You have stated in writ petition, my lord. Exactly, that is raising my lord's order, my lord. My lord pass the order on.
I cannot argue that.
No, you have stating. Here also you have stating. Well, let's see paragraph number 5, page number 5. Well, simply they have recorded in their case also, and here also. My lord, kindly see the writ petition, page 9. And my lord, this findings, my lord, in page 5, my lord, kindly see 10. Mr. Pamanik submits that the petitioner have admitted that the petitioner are having forensic report through other, not absolutely. Why?
I am not said on forensic report. I am not arguing.
You have stating, you have biopen affidavit, my lord, my lord. Kindly see their writ petition. Kindly see their writ petition. Maybe I am not understood, but written document is like this. But let's see the page number 19 of their writ petition.
I have got it opening submission from the other bank. I have said so.
No, my lord, kindly see their writ petition, my lord.
Question, what writ petition?
What you have, why you have written this thing?
Why? That
Giving
was
the
in
misleading
knowledge.
statement before
Yes,
this
you
writ
are
petition.
misleading the court by
My lord,
point
kindly
of
see.
every sentence is misleading.
Kindly see the page number 9, my lord, in their writ petition. They are stating exactly that is recorded in the my lord's order itself, my lord. And my lord dismiss this writ petition.
Here, my lord, my question is.
And same sort, I have a
the order
consortium.
passed by the committee. That's all.
No, you are not entering the room because I am not a state. This writ is not applicable,
Very
my
well.
lord.
Lordship, let me answer that.
Yes.
First of all, my lord, this is his best point. My lord, kindly take Muthoot Finance. It was a case of deposits, para 5.3. Finance company, case of deposit, para 5.3. In relation to a loan which contained an arbitration clause. Lordship has found out
Page?
Page number 2, para 5.3. This was, my lord, the fact scenario.
Of Muthoot Finance.
Yes, Muthoot Finance, my lord. Justice Padriwala and Justice Mahadevan is Subha versus Muthoot Finance. Lordship has seen 5.3. The following was the observed since on the facts financier acts contrary to the interim order. The petitioner merited entertainment notwithstanding the fact that petitioner is a private financer and would not be completely answered to the status of being a state under Article 12 of the Constitution forms of the function of the loan granted under the statutory requirement and enunciated by Reserve Bank order. On these fact, the petitions are entertained the amount of such and such. Now, kindly take 5.5. There's an arbitration clause and a dispute arising out of a loan agreement. Lordship has seen that?
Yes.
So, in this context, it has been said. Now, this has been considered by a coordinate bench. That in all fairness, this should have been told. In the case of Sushil Kumar Bhansali versus Reserve Bank of India. It has been considered. Kindly have a look. Paragraph 2, S. Sova versus Muthoot Finance, she has considered. But in case of willful defaulter, declaration of fraud, and paragraph 8, Lordship will take her order while she has considered. And I'm being very short, we are already. If it is under the Reserve Bank guidelines, circular, it is also maintainable. It's a private loan. If I will challenge a loan agreement, it's not maintainable. Paragraph 8. In relation to master circulation, master direction. This is Dreamlight Vapor versus Karuz Vaishya Bank, another coordinate bench. Same thing, challenging the master circulation. Paragraph 10, paragraph 112, and also takes paragraph 7. Sagar Thomas Federal Bank consider.
Yes.
And also a coordinate bench of Justice Shoposati Bhattacharya also considered Sagar Thomas Federal Bank paragraph 22 and 23. In respect of breach of master circular guidelines, which is maintainable. Karur Vaishya Bank এর রেটটা দিয়ে দাও এই তামিলনাড়ু মার্কেন্টাইল ব্যাংকের মামলাটা দাও and this is below
It is related to service matter. But Tamil Nadu Marketing देखो तो
service matter it's a show cause notice in relation to service and forensic audit.
Yes.
Kindly below in forensic audit Praveen Shelley versus Tamil Nadu Mercantile Bank Delhi. Kindly have a look at para 16 and 17. This is below Tamil Nadu Mercantile Bank. This is below in relation to below para 6 forensic audit, para 6 Lordship 5. Focus, para 9 and para 16 and 7. supreme order, but my lord, orders have been passed.
Yes, that's all.
Miller and your lordship's own view is there, Miller, which have been.
Well, that thing I clarified, my lord, what the particular date of resolution. I
Kindly
clarified.
Miller takes Miller, lordship's view as late as Miller, 3rd of Miller, August 2026. Up in appeal, Miller there is. Paragraph 45, 46, and Miller 47. This is lordship's view, Miller, in respect of a private bank dispute, Miller, which relates to closing of the bank account.
45, 46.
45, 46, 40. Lordship considered finished and lordship passed the order.
I have cited my lord's order, where my lord entirely same sets of doc.
I will hear you, no problem. I will hear you.
Kindly takes from paragraph 42, lordship paragraph, Miller. It's short. 42 to 47, lordship. You know, non-compliance of a master direction, master circular, breach of the provisions of surfacing notice, writ is always maintained. Okay, lordship has said, and for a moment I have not argued, Miller, regarding Miller non-service of Miller, the Miller report. They have not served me, but I have got it from other.
Well, they have recorded by open affidavit that I have not received. Well,
not
on page
argued
9 on their writ petition.
Yes, that is not the case. You haven't.
No, why you have written this thing by open affidavit? I am not getting any
If I have
forensic
ultimately got
report.
it, I have already got it.
That was also my lord, in my lord's order, my lord.
Very
In,
well.
in
Well, I have
case
5 grounds,
in
2
case
grounds I can succeed, 3 grounds I can fail. Merely because I have
it
stated
does
I
not
did that
of
to
fail or failure
yes.
to win. By open affidavit, you can say these all those things.
Got it from you. I am still saying so. I haven't got it from you. And Kirubai says, Millard, you have to give everything. The bank who is passing the order is due. Maybe in final hearing, lordship can get. You have got it from someone else, so it's an ideal formality. But I have to take that point.
Same point was taken. My lord decided that it to my lord's order, my lord. In this order, my lord in WP no 16473, same points raising, my lord, and my lord decided that issue.
I think this determination will continue. Then several judgment will be there.
Yes, absolutely. I have already finished, Millard. My point is, Millard, there is no signature of the committee. There is no constitution of the committee. It has been served by the senior manager of the bank. Is it permissible as per the circular? 2017 circular also says it is not permissible.
You satisfy the whole the resolution.
I will, my lord, I will back on a supplementary
resolution.
affidavit. I clarify on that particular day resolution, how the resolution passed, where the signature or resolution books, all those things.
Correct. Because if it is resolution only taken and there is no signature, it is settled law. Without the signature of the resolution cannot be.
Maybe I am not sure. There is so many resolution passed. They are giving the particular resolution. That's why there is no signature.
Maybe.
Although, my lord, I asked for my direct file, my lord, the copy of the resolution. Where is the signature of my banks?
And the point what I have taken, because Millard, in the case of Millard, State Bank of India versus Amit Iron, lordship has seen it many times. Para 126 conclusion subparagraph B says that Millard, I have to, Millard, they have to give it. Lordship final hearing, if I challenge it on vitiation, lordship can of course say, you have got it from State Bank of India, why Tamil Nadu will give it. But they haven't given it, it is my right to get it. Whether lordship is right, lordship is, but Millard, that is up enough. There is no say on that. But Millard, the obligation to give is on the bank. Lordship may not vitiate the order for non-publishing because I have got it from the others.
But my lord, again I am repeating at the cost of repetition. My lord, discuss this issue, my lord's order. This thing, my lord. In that case, they are also not getting, but they are getting from other banks.
Challenge here. My principal challenge is an unsigned law.
No, in that case,
a principal challenge, I will carry.
In that case, they have not challenged with regard to the forensic report was not served. They have not. Okay, well, I will see.
Yes, I'm accepting. I have got it. I said opening submission. Because Lordship, the first day I say personal hearing, I cannot argue that the Supreme Court judgment of this waters down the judgment which has that para 4 has been appended, para 4, that he has to give me the copy. But anyway, I'm not going to that. I'm only on the order, the ordering part.
I will clarify, my lord, weapon affidavit, this person, what's my lord found me, directly, I'll find. Provide the signature of the.
Clarify. The order will not improve Mohindra Singh.
No, not affidavit, you bring the whatever the.
My lord, yes, I must be there, my lord. It's a banks, they are not doing their, like a.
The order
must
has to be
there.
given by
My
the
lord,
commission.
I have shown, my lord, the resolution copy.
Why I am telling, the same issue was raised in another matter. So then the same thing, constitution of the committee and the signing by the assistant manager. Then I called the point was raised. Then the bank has produced the separate order of constituting the committee in that order. Because if the committee is consisting of 3 members, in that order, bank is taking the minutes, taking the decision. Yes, assistant manager will be the what officer it called?
Forwarding officer.
My lord, page 87, kindly see page 87 once, kindly. Resolved that the approval of committee B and is hereby granted for the followings.
87 of?
87 of my lord affidavit, my lord, my affidavit, report on affidavit on behalf of the respondent.
That's why I am telling. That's why if it is signed by not
yes,
even the
yes.
member, what
Yes,
the
yes, yes.
chairperson, that
Yes,
also will.
I will clarify.
Correct.
This
That's
will-
what I'm telling.
This will give go and they have to give.
That's
a
I'm
fresh
telling.
hearing,
If
that's
you
all.
are because you have acted on the
Signed
basis.
copy.
Yes. So whether this
Resolutions.
resolution is signed by the total.
Well,
Because the division bench is going as far as saying.
Well, must be, my lord,
Division
without
bench,
getting the copies
that
of the.
if there's a signed copy, there's an obligation on him to serve me.
Correct.
Otherwise, it has to be set aside.
Unless how you.
Unless you serve, you cannot. If you don't serve, you are a lost duck. What happens? I will nowadays see appearing from the authority. Now, the best thing to do is to set up and give me a hearing. That is, I am agreeing also. There are
If
procedural matches. That's all.
decided that this REIT is applicable here, then the question of all those things.
It is maintainable. Now courts have said so. Muthoot Finance is a case of breach of loan agreement. How does it apply here?
Yeah, also the banking company.
Yes, banking.
Banking, but here is the violation of the statutory rules.
The violation of the statutory rules, maintainable, my right.
Violation of the statutory rules for which the party's right has been affected.
Well, that notification, my responsible submission is not applicable because prior to that I am.
If it is not, then your 16 notification is
Yes,
there.
according to 16, I am.
16 notification also the same value.
Same thing.
16 notification is also the same value.
Well, I am doing according to 16 notification.
Correct.
And all those things are not applicable in this latest notification because it is my perception, my lord. Because I have started the prior the notices, all those things I am sending prior to coming.
No, see,
Okay, my lord, I will file these copies of the resolution, signed copies of the resolution.
Come.
Fine.
The counsel for the petition has concluded the argument. Full stop. Counsel for the respondents press for time to time according cases adjourned. Let the matter up. When you will come?
My lord, 4 weeks because it's outside. 4 weeks.
Let the matter appear on 9th.
4 weeks, my lord, because
4 weeks.
4 weeks.
My lord, because my lord, kindly see the branch is everything.
Where is the mercantile bank?
Tamil Nadu, Tuticorin, my lord.
You are not having the.
Here is the branch, only one branch, my lord. But my lord, kindly appreciate one branch in eastern region, only 2 branch. This person is my lord, because we have to send in from Tuticorin, my lord.
Branch, where your branch is having?
Here, Calcutta, Bevon Road, my lord. Just behind the writers building, there is a branch, my lord.
Let us finish it up before.
Today we are on 21st. Come on 9th.
Okay.
9th September.
Interim order.
Interim order is extended till 11th September or until further order which.
ভালো মামলা করতে গিয়ে
কি? হ্যাঁ? কইটা?
আমি আছি
আমরা কাজ করতাম, অনেক কাজ করা আছে।